Good afternoon, everyone. The Appellate Division, First Department, is now in session. Our first order of business will be to call the calendar. I'm going to ask that you please state your appearance when you hear your case called, and I will indicate to you the time that's been allotted for your argument. I want you to please keep in mind that we have 13 cases to be argued today, so pay attention to the time that you've been given. It's not that we wouldn't like to give you more time, it's just that in order to accommodate everybody's need to be heard, we've had to limit your requests. The first case, People v. Frank De Jesus. No appearances on that?
Your Honor, Michael Yetter for the...
Go ahead.
I'm sorry, Michael Yetter for the respondent, People.
And do we have somebody for the appellant?
Yes,
Ms. Cohn?
Your Honor, Tabitha Cohen from the Office of the Appellate Defender.
Okay. All right. The defendant's been allotted 3 and 1 and the respondent 3 minutes. Abalo versus Trustees of Colombia.
Yes, Shania Boyd for Colombia, and I would like to renew my request for rebuttal time since this is a cross appeal.
Let me hear from everyone else. You didn't ask for it before, and I don't know that you're renewing. This is the first I hear of it. So it's not technically a renewal, but that's okay.
Your Honor,
right.
I forwarded in my original request.
Well, it never made it to the court. All right. Can we, let's go on with the requests. With the appearances.
Brian Battisti from McElroy Deutsch on behalf of Titan Plumbing and Heating. Good afternoon, Your Honors.
Respondent, plaintiff, Mr. Wagner.
Andrew Wanger for plaintiff respondent, Daniel Abalo.
All right, I will in fact give Columbia rebuttal time. So your argument time now will be 4 and 1 instead of 5. Titan, you have 5 and 1. And plaintiff respondent, you have 4. Okay, Melanie C. versus Carlo B.
Bruce Young for appellant. Good afternoon, Judge.
Good afternoon.
Helen Carvalho for the respondent. Good afternoon.
Good afternoon. All right, the appellant is given 5 and 2 for rebuttal, and the respondent is given 2 minutes for argument. Viniello versus New York City Health and Hospitals.
Good afternoon, Jesse Townsend for the appellant, New York City Health and Hospitals.
Brian Isaac, Your Honor, for the respondent.
And the time allotted is 5 and 2 rebuttal for the appellant, 5 for the respondent. People versus Vance.
Good afternoon, Your Honor. Jonathan Croyce for respondent, Mr. Vance standing in for ADA Lauren Breen.
Don't we have an appellant?
I believe we do, Your Honor.
Mr. LeBrew?
At 1:30.
What do you mean at 1:30? He was here at 1:30?
Yes, ma'am.
Yeah. Well, it's possible he's having technical difficulties. Do you have a way of contacting him, Mr. Croy?
I can send him an email.
Yeah, or text him and just let him know. But the time allotted is 5 and 2 and 5.
Yes, ma'am.
Okay. People versus Jonathas.
Good afternoon, Justice Gish. My name is Peter Tillum, T-I-L-E-M, Tillum and Associates on behalf of the appellant, Mr. Jonathas.
Good afternoon, ADA Amanda Regan on behalf of the people.
All right, thank you. And the time you're allotted is 5 and 2 for the appellant, 5 for the respondent.
Thank you.
111 West 57th Street versus 111 West 57th Mezzanine.
Good afternoon, Justice Gish. Stephen Sinatra, Greenberg Chorig, counsel for the appellant.
Good afternoon, Justice Gish. This is Eugene Myers, Meister Seelig and Fine, counsel for 111 West 57th Investment LLC, and I'm joined by co-counsel Haley Proctor from Cooper and Kirk, who is appearing. She's an out-of-state attorney. She's been granted permission pro vice to argue today, and I introduce her here.
All right, and the time allotted for the appeal and cross appeal are 6 and 2 for rebuttal for each of the parties.
Thank you.
Moore versus Nisen.
On behalf of the appellant, Your Honor, Jason Melissa.
We're getting some feedback. Please restate your opinions again.
I'm sorry, Your Honor, Jason Melissa for the appellant.
7, 12, 13.
Respondent? We can't hear you, Ms. Friedman. Yeah. You're muted.
Thank you. Good afternoon. Elizabeth Friedman appearing for respondents, Dr. Mark Ingram and Health and Hospitals.
All right, the time is 1 and 3. Am I getting feedback? Am I the only one? I guess so. All right. Okay, People versus Angel Eric P. Submitted. Sabre Chemicals versus Northeast Chemicals.
Michael Kuzo, Westerman Sheehy for defendant appellate Northeast Chemicals.
Good afternoon, Your Honor. Eric Grayson of Grayson and Associates for respondent Sabre Chemicals.
All right, you're granted 6 and 2 for the appellant and 6 for the respondent. Carlin versus Pierce.
Good afternoon, Your Honor. Steve Colmar, KOMMOR, on behalf of the appellant. Good afternoon again, Your Honor.
Good afternoon, Evan Secular, Brian Perskin and Associates on behalf of the respondent, Christopher Pierce.
Good afternoon, Your Honor. On behalf of the child, Stephen Forbes.
Your Honor, I'd like to amend my time if possible to 3 and 1. I don't need that much time.
And you, I'm sorry, you represent the appellant?
Yes, Your Honor.
3 and 1?
3 and 1.
Fine. You're asking me for less time. That's fine.
Yes, Your Honor.
I will not complain about that. All right, so you're granted 3 and 1 for the appellant, 3 for the respondent, and 3 for the attorney for the child. Advanced Aerofoil versus Mission Point Capital.
Good afternoon, Your Honor. Eric Latzer on behalf of the appellant.
Mr. Weiss.
Good afternoon, Your Honor. Jordan Weiss of Goodwin Proctor on behalf of respondent Mission Point Capital.
All right. The appellant gets 6 and 2, the respondent 6. People versus David Santos is a submit. Harris versus Harris.
Good afternoon, Your Honor. Nader Mobarga for appellants Bernice Harris and Allison Harris Shafini. And I'd like to request 1 minute rebuttal time for 3 minutes if possible. Thank you.
And this is Tammy Harris for respondent pro se.
Your Honor, this is Daniel Murphy for defendant appellant Andrew Lichtenstein.
All right, I'll allow the Harris appellants to reserve 1 minute for rebuttal. That means you have 2 minutes for argument. Appellant Lichtenstein, you get 3 minutes for argument. And Ms. Harris, you get 3 minutes.
Thank you.
Butler versus New York City Transit Authority is submit. Stafford versus A&E Real Estate is submit. Garsilpi versus Gorman.
Good afternoon, Your Honor. Rich Schoenstein for the appellant. I would like to take my 3 minutes and split it up 2 and 1 and reserve a minute for rebuttal, if I may.
Ms. Ryan?
Your Honor, this is Catherine Ryan from Lewis Brisbois on behalf of respondent Garsilpi.
All right, Mr. Schoenstein, I will allow you 2 and 1. and 3 for the respondent. Let me just remind the parties, please, because there were a lot of late requests for time and differing requests in the calendar call, that it is very cumbersome for us to change the times. And so please be mindful when you make your requests to make them accurately and timely, and that would help the court out a lot. Okay. First case on the calendar, People versus Frank De Jesus. You may proceed. Ms. Goen?
Yes, Your Honor. May it please the court? Tabitha Cohen from the Office of the Appellate Defender on behalf of Frank De Jesus. The prosecutor in this case assessed all of the facts and circumstances of the case and determined that it was worth the minimum. He repeatedly stated on the record that he was offering Mr. De Jesus the minimum sentence. He just made a mistake.
Counsel, this is Judge Mendez. Didn't the prosecutor offer the minimum of 8, which is not exactly the minimum, because we know that the minimum is 6, but the prosecutor stated on the record, we're offering the minimum of 8.
Exactly, Your Honor. The prosecutor made a mistake. He thought that the minimum was 8, and then the court corrected him and said, actually, the minimum is 6. And that's when the prosecutor doubled down and insisted that the offer was still 8 years, in effect changing the offer from the minimum to the minimum plus 2 years.
But that was the offer that was made, and that was the offer that was accepted by the defendant, wasn't it?
Yes, this was a negotiated plea on the understanding that he was receiving the minimum. However,
I disagree. Wasn't the minimum that was offered, based on the conversation that we just had right now, 8 years as opposed to 6?
The prosecutor said the minimum, which is 8 years. And then the court corrected the prosecutor and said that the minimum was actually 6 years.
Yeah,
and yes.
This is Judge Gish. I have a question. So let's assume there was certainly some misunderstanding about whether the minimum was 8 or 6, and possibly some misunderstanding between the parties about whether the offer was the minimum or 8. But then the prosecutor cleared it up and said, nope, now I know the minimum is not 8, it's 6, but I'm offering 8. Couldn't your client at that time have said, well, then I don't accept this plea? That didn't happen. Didn't happen. They took the plea anyway. And in fact, actually, the defense attorney said to the judge, would you make it 6? And the court said, no, I won't. And actually couldn't, because you got a reduced charge. So I really don't really understand this idea that there was a problem here with the 8, that your client didn't accept the 8. Your client, as far as I'm concerned, did. What am I missing?
There's no question that Mr. De Jesus planned on accepting responsibility for what he did here. However, the prosecutor decided to plead this case down to an A2 in light of all of the circumstances, and also thought it was appropriate to offer the minimum on that A2, given all of the mitigating circumstances at issue here.
Yeah, I guess that's where we differ. I don't think. I think that the prosecutor cleared up what the intention was once the mistake was brought. And then if your client was under a misapprehension, that would have been the time to speak up and say, okay, no plea. Okay. All right. Let's hear from your adversary.
Good afternoon, Your Honors. Michael Yetter for the People. I think as some of the questioning is borne out, the prosecutor did initially miscalculate what the minimum was, but he always intended to offer 8 years. That was borne out throughout the rest of the plea proceeding. That was borne out. We don't really
know that, but the prosecutor didn't own up and say, no, I really only never acceded to.
17th, where the defendant raised the question again with the judge made clear they weren't offering you the 6 years. And that's, that was the case for sentencing as well.
It was a reduced charge, right?
No, correct as to the judge. But what I meant was the judge was telling the defendant the people didn't offer you 6, they offered you 8. And that's what the record bears out. And I would just note finally, defendant also vowed we waived his right to appeal in this case. So the court should affirm for that reason as well. Thank you.
Okay, 1 minute for rebuttal.
Your Honor, very briefly on the appeal waiver, this court held, the Court of Appeals held that a very similar colloquy on the appeal waiver was invalid in the Bisono case just a couple of months ago, where the court indicated that by signing the appeal waiver, the conviction was final.
And so here's the question on the Bisono issue, though, which I don't think the Court of Appeals addressed, which is, can a written waiver that is accurate correct that Bisono mistake?
Yes, Your Honor. In Bisono, there was a written waiver in the Daniels case, and the court still held that the written waiver could not be a substitute for a proper colloquy, especially when the court made affirmative misstatements to the defendant on the record. Additionally, we are asking for a modest sentence reduction of 2 years. Mr. De Jesus is in his 50s. It will make a world of difference to him, for this court to correct the prosecutor's mistake and abide by their original promise of the minimum.
Okay. Thank you. Oops. Next case, Abalo versus Trustees of Colombia.
May it please the court, Janaea Boyd for Colombia. Your Honor, Supreme Court erred when it determined that sanctions should be imposed upon Colombia due to spoliation of evidence. Titan failed to meet its burden establishing that Colombia had the obligation to preserve the toilet at the time of its disposal. So
I don't know when it was disposed, when the toilet was disposed, Colombia was aware that there had been an accident, correct?
Colombia was aware there was an accident, but they were not aware as the cause of the accident at the time the toilet was disposed of. So,
well, hadn't they called in the plumber to investigate it? And wasn't it that plumber that helped them dispose of the toilet?
They called the plumber to investigate the source of the leak. So even when they called in they didn't know that it was the toilet that was causing the issue at that time.
Maybe, counsel, when they called the plumber in to discuss the source of the leak, the plumber determined that the source of the leak was the toilet. That's why the toilet was replaced. So once they replaced the toilet, because it's the source of the leak that contributes to this accident, don't you think that at that point they would more or less have an idea that this toilet could be, a piece of evidence that someone may want to look at in the future because somebody got hurt here?
Well, Your Honor, we submit that the super that was there when the toilet was replaced, he testifies that he still didn't know whether the toilet was defective or not. It wasn't really until the findings in the APH report that was given to Ms. Ryder where it was discovered that there was an issue with the seal. But by the time the report came out, the toilet had been disposed of. And the toilet was disposed of in the APH's ordinary course of business. That is undisputed here. Both the HPH plumber as well as the principal testified that they normally throw away these toilets. There's no way to trace their whereabouts. So in this court, as well as other courts have held, if evidence such as a toilet or records, etc., is disposed of in its ordinary course of business, then sanctions are unwarranted in that instance. Also, Your Honor.
Well, can't you have spoliation sanctions for negligent conduct? Isn't negligence also a culpable state of mind for spoliation?
Yes, Your Honor, but we submit that there's no negligence here because there was no notice to Colombia that the toilet should be disposed at the time that the toilet was discarded. Also, disposal of the toilet did not deprive Titan of its ability to mount a defense of this case. Indeed, it's moving for motion. It made a motion for summary judgment. There's a plethora of other evidence in this case where a jury can conclude whether or not Titan negligently installed the toilet. There's plenty of testimony from other plumbers, as well as the APH report, as well as Mr. Mustella's report as well. So the toilet is not critical evidence in this case. Unless the court has any other questions regarding spoliation, I'll move on to Titan's motion for summary judgment. Titan.
You have another minute.
So Titan argues that the toilet is critical evidence, and yet in the same breath states that it's met as prima facie burden. We submit that not only the toilet is not critical evidence, but there's the evidence in the record demonstrates that there are tribal issues of fact as to the source of the leak, Your Honor. So there's testimony from plumbers stating that the leak can occur over time. Just because there was no leak when the toilet was initially installed by Titan does not mean a leak cannot occur over time if the toilet is negligently installed. There's also testimony from the tenant above the apartment at issue stating that there were issues with the toilet in between the time Titan installed the toilet as well and when the incident occurred. We also have the APH report, as I mentioned, that states that the toilet was not properly installed, that the seal was not properly installed, as well as Mr.
Finish up. You'll have a minute on rebuttal.
Yes, and just to conclude, we believe that spoliation sanctions were not proper in this case, and also that the Supreme Court properly denied the motion for summary judgment.
Okay, thank you. All right, Mr. Yetter.
Brian Battisti on behalf of Titan Plumbing and Heating.
Oh, I'm sorry. Okay, go ahead.
Thank you, Your Honor. With regards to the spoliation issue, I think the record is clear that Columbia's superintendent took pictures on the date of the accident, requested the Alpha Janus Plumbing and Heating come in to find the cause of the leak. The Miss Ryder requested them to create a letter as to the cause of the leak with regards to the toilet. It's clear they knew that there was
Judge Singh, Counselor.
Yes.
How was your defense prejudiced by the toilet not being available? Because my understanding that the negligence is really a negligent installation with respect to the gasket as opposed to something wrong with the toilet itself.
Well, why it's crucial to the defense is part of the motion for summary judgment. The only testimony we have, the only two people we have who actually saw the toilet, have a recollection of seeing the toilet, say the toilet was installed properly and that there was no issues. We cannot properly defend.
But Counselor, there's evidence in the record that this can occur over time, right?
Right, but how are we to?
Because it's the using of the toilet over time, which I guess loosens the seal and permits water to leak. Correct?
That is the allegation, correct. Right. And the reason it is crucial to our defense is because when the experts are able to actually inspect the toilet, they would be able to say, here is where the gasket, here is the bolt that was over tightened.
But why not any toilet? Why not a similar model? If you're just seeking to depict it, saying this is how a toilet is installed, etc., it doesn't have to be the same toilet, right? Can't you use a model to show that?
No, because the expert needs to actually connect up the condition of the toilet to the condition of the installation. They have to be able to say.
This is Judge Scarpullo. Wasn't there also testimony that the super saw that the top of the toilet, the numbers on the top of the toilet didn't match the toilet? So there may have been an issue about that, whether that helped or exacerbated the condition. I recall that the upstairs neighbors said,
Miss White,
that the top and the bottom of the toilet serial numbers didn't match.
Correct. Miss White testified that Mr. Herrera had told her something that maybe the top and the bottom didn't match.
So
and
that might be some reason why you'd need that actual toilet, right?
Correct. Yes. With regards, and unless there's any other questions, I'll move on to the summary judgment aspect. And I already started to address it in the fact that the only testimony we have with regards to the actual toilet itself, not speculation of what could happen over time, is that the toilet was watched by Columbia's superintendent, watched it be installed, he inspected it, and it was tested, and there was no problems with that. Everything else is just conjecture, speculation.
Well, that's not exactly true, Mr. Battisti, at least for the purposes of creating an issue of fact. The super did see that there was water in and around the toilet later on, right?
Correct, but
and we also have the upstairs neighbor who said, I didn't do anything to change that installation. I didn't jiggle it around. I didn't hit it. I didn't do anything to it. So why isn't that at least circumstantially enough to create an issue of fact to deny you summary judgment?
our position is that a leak in the toilet, and there was multiple plunging incidents. I'm at the appellate court talking about plunging a toilet, but there was multiple plunging incidents in between the time it was installed and the time that it was removed. So a leak in the toilet does not actually link up to an issue with the installation, right? If we had the toilet,
it might though. That's not. We're not doing issue finding here. It possibly could.
But by establishing our entitlement to summary judgment, there has to be something more than it could have or it might. There has to be a link that says
circumstantial evidence will do it, though, right?
I don't think that raises a trial issue effect because there's no foundational
I understand
fact.
That's your position, and I'm trying to understand why not. Doesn't have to be dispositive. Doesn't have to be the strongest. Yeah.
Also, Counselor, you're in the toilet installer. He acknowledges that leaks can develop over time if the gasket is not properly placed. So it comes from your own witness.
Any toilet, correct, but not to this specific toilet. And that goes back to why the toilet's so crucial. So we could actually see the gasket and say, no, this gasket was set right, because there's multiple testimony. There's testimony from Mr. Herrera that says it has nothing to do with a gasket. It's a crack in the bottom of the toilet. It says it's a crack in the bottom of the top.
You'll have time on rebuttal, Mr. Batista. You'll have time. All right, let's hear from Mr. Wagner.
Good afternoon, Your Honors. May it please the court, Andrew Wanger for plaintiff respondent Daniel Abalo. So I just want to address something Mr. Batista keeps saying, and he's repeated in his brief, and that is that there's only two people with personal knowledge, and that's the super and the installer. But in fact, Mr. Aloa knows absolutely nothing about what he did that day. He has no recollection of installing the toilet. He has no recollection of whether or not he even inspected the toilet. He has actually nothing dispositive to offer this court whatsoever. And the same for Mr. Herrera. There's no evidence that he actually inspected the installation. He flushed it a couple times, and we would argue that that's not enough. The other thing is that Mr. Aloa and Mr. Herrera are both not plumbers. I'm not even sure they're qualified to opine as to what a proper inspection looks like. The other issue is that, like Your Honors have pointed out, this is a type of leak that occurs over time. And so even if they had inspected it, at the time it was installed, it wouldn't be sufficient to detect the leak that we claim occurred here. And the other thing is that Mr. Herrera's deposition testimony actually supports our case. He specifically says that he agrees with the statement from Alvagianis that the toilet was not set properly, basically that it wasn't installed properly. He admitted that the toilet was leaking on the day of the accident. He admitted that the toilet was actually the cause of the accident. That's my case, and that's what Titan submitted as part of their prima facie proof, which actually, so it's ironic that their prima facie, their attempt to establish a prima facie case establishes my prima facie case. And the other thing is, as the court has already pointed out, the other plumbers said that this can happen over time, and that's also part of their submission. But even if we assume for a second that Titan had met their burden, which I don't think they did, we submitted a really detailed 9-page affidavit from a master plumber with 30+ years of experience, who said that the only explanation for the leak was Titan's negligent installation. He considered other causes, and he ruled those out. And in fact, our plumber, Mr. Musella, he's the only person in this entire case who reviewed all the deposition testimony, the spec sheet, and the parts list, and who was familiar with the make and model and the operation of this specific toilet. And Mr. Battisti, counsel for Titan, is the only person rebutting my expert's opinion. And I would argue that attorney speak is not evidence. And if he wanted to say that my expert was speculating, he should have gotten an expert of his own to explain what information my expert should have had that he didn't have, that he needed to render an appropriate opinion. I think, for all of these reasons, the lower court should be affirmed. And if there's no further questions, I'll rest on my papers. Thank you very much for the opportunity to be heard today.
Any questions? Okay. All right, Ms. Boyd, you have a minute for rebuttal. Let me just first state, I called you by an incorrect name earlier. I apologize, but I now know you are Ms. Boyd. Go ahead. You have your time.
Thank you, Your Honor. As far as spoliation of evidence is concerned, the super took pictures of the bathroom where the accident. He did not take pictures of the toilet, the upstairs apartment. So I know Titans Counsel mentioned that earlier, so I just want to clarify the point. Also, Ms. Ryder requested the report well after the toilet had been disposed of. So by the time she requested the report, the toilet was discarded. So they have to show or demonstrate that at the time the toilet was discarded, Colombia had an obligation to preserve it, and Colombia did not. And if the court has questions, I will
Any questions, colleagues? All right, Mr. Batista, final word.
Yes, very briefly. When I say the only two individuals with regards to the toilet, I'm referring to Ms. White, the tenant, as well as Mr. Herrera. All right, with regards to plaintiff's expert, he did not review all the deposition transcripts. He did not review the second deposition transcript of Mr. Herrera, nor did he review the deposition transcript of Ms. White. I also note that he didn't inspect the toilet, didn't see pictures of the toilet.
Doesn't this all go to weight, Counselor, as opposed to, whether it raises an issue of fact?
I think it goes to the fact that he lacks any foundational facts with regards to this specific toilet, to this specific item of evidence where he's just printing out something off the internet and saying, oh, this is a possible explanation as to what it was, especially when he lacks a review of the testimony of the tenant who lived with the toilet for 3 months. Unless there's any further questions, we'll rest on our papers. Thank you, Your Honors.
Thank you all, counselors. The next case is Melanie C. versus Carlo B.
Bruce Young for the appellant.
You may proceed, Mr. Young.
Thank you, Judge. We raised the issues here. There's the jurisdictional competition. There's issues of comedy. There's procedural issues that were misapplied, but primarily a New York court obtained jurisdiction through the appellant's waiver and consent to proceed under the international phone rules under 433 of the Family Court Act. These are things we're now grappling with now more to be able to send documents and videos as we have, the pandemic has accelerated our competency for that. But in this case,
this is Judge Scarpula. Isn't it true that on June 1st, 2018, your client signed a document that said each party agrees and that Kira's habitual residence is in the United States, in Manhattan. The mother had residential and physical custody of Kira there. They accepted that jurisdiction should remain in the U.S. and specifically in the New York courts. And your client signed that document, correct?
He did, and
so now you're saying, oh, but let's not pay attention to that.
Well, the Italian.
I mean, anyone can waive or chart their own course or choose or not choose to subject themselves to jurisdiction. And your client straight up said, with respect to this child, New York, the child is here, I'm here, I'm going to litigate it in New York. And now you're telling me there's no jurisdiction? How could that be?
3 months later, after that document was signed, the Italian courts found that it would be harmful to the child to return the child to New York. So the U.S. Supreme Court recently.
1 second. That Italian court decision was overturned on appeal, correct?
There have been 16 litigations, and I believe even one of as of a week ago did refuse to order the return of the child. That's what I'm informed of.
May I ask a question, though, Mr. Young?
Yes.
That was under the Hague Convention, which is the physical return of the child. But that doesn't deal with the issue of jurisdiction as to what court should make the determination about the disputed issues. Even under the Hague Convention, that's just for a physical return of the child, period, right? Not who makes the decision. It's pretty clear here. New York is to make the decision regardless of where the child is physically.
I'm not disputing. My client consented and tried to participate fully in the litigation in New York. He sent a fax, numerous pages detailing what was occurring. He attached Italian court orders. What's troubling is that these are clear and convincing evidence for a willful violation resulting in incarceration for a civil litigant. And of course, the Powers case flips that on its head and says, if you don't pay, it creates a presumption, and now you got to create the rebuttal. However, I don't think that even applies in this instance, because when you send an Italian court order that says the court, they find it would be harmful to return the child, and they acknowledge receipt of that order, the support magistrate did, and then does not acknowledge anything about that order and disregards it. And the presumption he relied upon was that he refused to return the child pursuant to a New York court order, when the Italian court order was saying it would be harmful to the child. And it's been consistently reapplied on that issue.
But I don't understand. There was no change in the child support order. He had never petitioned for a change in custody, which would have been in New York courts. He had never petitioned to modify the support order, which he would have been required to do to keep that money from kind of accruing. He had a September 2018 stipulation where he admitted that as of that time, $14,000 was owing. He admitted that that amount was never paid. So the purge amount for the contempt was even under that $14,000. So how do you get out from under that?
Well, first, he does stand by, and we put that in our brief, stands by the part of the arrears that were signed off on in June of 2018 for $14,000. He agrees, he still agrees that he owes that amount. What he's objecting to is the continuing support and the add-ons that were imposed and are apparently continuing to.
But again, how can you change that without an order of the New York court modifying the support obligation? That's what I don't understand. And that doesn't really have much to do with whether the Italian court said under the Hague Convention, return the child or don't return the child.
In the supplemental appendix, his fax that was sent to the court before his very first appearance expressly informed the court of these situations and asked to at least suspend the order, that it was unfair for that purpose. Even though it's a pro se order, he did not come to New York. I'm actually, even as an appellate lawyer, constrained that I'm assigned to represent him only on the willful incarceration part. I'm not authorized to file such a petition on his behalf.
Right, that's correct, because we don't assign counsel for that to anybody. Doesn't matter that he lived in Italy. We just don't assign counsel unless there's a specter of incarceration. All right, let's hear from your adversary.
Thank you, Your Honors. With regards to child support, I think it's clear that Mrs. Colon satisfied her burden of proof. Not only did she provide all the the stipulation of 2018 and the previous orders, including the judgment of divorce, she included a summary of arrears, and the father, as you just said, testified and acknowledged that he had to make those payments and that.
Well, here's my question, and I think it's been questioned on appeal. A summary of arrears isn't proof of arrears. What did she provide that backed up the arrears? I mean, the $14,000 seems pretty clear, but what did she provide otherwise in terms of proof?
So first, she provided all the orders, which mainly the 350 euros per month that the father owes. And this is based on the order, and it was accruing over the time. And then in the first summary of arrears of June 2018, there was a spreadsheet of the expenses and explanation of where it came from. I believe it was 12 pages. And the father reviewed those documents and didn't question them. But the main amount of those child support arrears is the 350 basic child support payment anyway. And the father
true enough, but we're looking to hold him in contempt here. I mean, if he doesn't purge, he winds up in jail. If he sets foot in the United States, I mean, that's pretty significant, you know, so we don't want to be, what's the word? We want to be really precise about the money before we put somebody in jail, right?
No, of
course. You'd agree with that.
No, of course, but as you just said, the arrears of $14,000 is straightforward. And for the rest, the father acknowledges everything about it. So, and he's trying to explain, and he also shows that his expenses and his income have not changed since the stipulation of 2018. So he's as well able to pay today than he was in 2018 when he, represented by counsel, signed this stipulation. So in terms of custody, I think this court has understood the problem. There is no decree, no order in Italy or in New York that says that the child's residence is in Italy with the father, and that says that Italian courts have jurisdiction somehow over custody anyway. And actually, we are back in front of Mrs. Olshansky in April. So.
Okay. All right, let's hear rebuttal from Mr. Young.
Thank you, Your Honor. I think the thing that glares at me with this is the element of jurisdictional competition, the failure to actually acknowledge an order that brings out the problem. It was not addressed in the underlying order. The issue, it's sort of lurking in these nuances of habitual residence, which the U.S. Supreme Court in the Monosky case came down with last year, addressing it more of a totality of circumstances, and particularly when a child is at this age and maturity and expression, that is a major factor, despite if both parents agree to a child that's now 16 and a half that they're going to reside in New York, and they haven't changed that, but the child's changed it by saying, I'm going to stay in Italy and I'm refusing to go back, and the Italian courts are saying it would be emotionally harmful to return the child. That's a factor that was not considered in creating the presumption of willful violation of a serious issue, which creates the.
Are you confusing though? Are we confusing here the willful violation of paying support with the violation of the agreement to send back the child? Aren't those two different things?
Yeah, there are two different things, certainly, but the issue is that the magistrate.
So, and habitual residence, that's the concept under the Hague Convention, under kidnapping, right? For return of child.
Right.
Correct?
And there were orders, and an order at the time the decision came down.
He's not being held in contempt for failing to return the child. He's being held in contempt for failure to pay an outstanding order of support. That's where I'm having some conceptual problems with this.
I think it goes back to the original issue, is that a presumption of willfulness is created, like an unusual situation. You can have incarceration because it's based on a presumption. In the express findings of the magistrate, a major presumption that he relied upon was by not returning the child pursuant to the New York custody order, without acknowledging that an Italian order said that the child. But
again, let me stop you, because we don't need a presumption here. He admitted he didn't pay the $14,000. That's pretty willful. I mean,
Well, he didn't pay the arrears and stands by that he still is obliged to pay the $14,000.
Yeah, but he didn't pay a penny towards it. That sounds pretty willful to me. Just saying. All right. I think we understand your arguments. Thank you. Thank you
for
both.
the opportunity, Judge.
And the next case is Viniello versus New York City Health and Hospital.
Good afternoon, Your Honors. Jesse Townsend for the appellant. Your Honors, Supreme Court erred in denying summary judgment as to the appellant on two independent grounds. First, as to all the allegations predating September 2015, Supreme Court erred in denying summary judgment on the grounds that the allegations were untimely and that no toll applied. And then second, as to the remaining alleged acts and omissions, the court erred in denying summary judgment on the grounds that the plaintiff's expert opinion was unqualified and unsupported by the record. So turning first to the timeliness issue. It is undisputed that the plaintiff's allegations concerning Bellevue Hospital's alleged acts and omissions before September 2015 are facially untimely. And so it was plaintiff's burden to come forward with evidence that the continuing treatment toll applied. But for the toll to apply, there must be evidence that there were ongoing efforts to treat the particular complaint and that both patient and provider explicitly anticipated those efforts would continue. And plaintiff cannot show that a course of treatment was established, let alone continued before September 2015 for the particular complaint of blood in plaintiff's stool. What the medical records show is that plaintiff went to Bellevue emergency room once in April 2013, was told to follow up with specialists, was told to do so again during a visit to the general medicine clinic, and then went to the gastroenterology clinic for this symptom once in July 2013 in preparation for an August 2013 colonoscopy. But that colonoscopy did not occur, and there is nothing further in the medical records documenting any effort to treat this complaint or symptom.
Now, Counselor, in December of, I think it was 2013, when he went for conceitedly an unrelated procedure, there was a reference by the anesthesiologist, right, that relates to the colon cancer. Is that a basis upon which there could be, I guess, a finding of continuous treatment?
Thank you for raising that, Justice Singh. The answer is no, and here's why. As you noted, the physicians are, in the context of treating an unrelated condition, preparing the patient for a surgery, a urological surgery. And plaintiff discloses these other conditions that he's complaining of, one of which is blood in the stool. And what the urologist, according to the anesthesiologist note, says is there should be follow-up. But nothing actually happens, either with physician or patient, to actually.
Well, but wouldn't it be the hospital's obligation then to follow up? If there's a notation that there is blood in the stool, which is a serious condition.
I don't think that that's solely on the hospital. That would be both patient and physician need to establish a course of treatment. I think that note by itself, that notation, is very similar to the Nykorchek versus Enriquez case. Apologies if I'm mispronouncing either party's name, where the Court of Appeals noted that a physician noticed a lump in a patient's breast, misdiagnosed it as non-cancerous, and said, we should keep an eye on this. And then nothing else happened. That's just statement doesn't establish a course of treatment. There's no prescriptions. There's no dietary changes recommended. There's no request for further treatment or appointments of any sort.
What about the plaintiff's statements that he did make several undocumented visits to Bellevue in 2014 for rectal bleeding? Why wouldn't that create an issue of fact?
So two responses, two reasons why it doesn't, Your Honor. The first is that the Court of Appeals has at least twice noted that where a plaintiff testifies to further medical interactions beyond what is documented in the medical records, that's insufficient to create an issue of fact on the continuing treatment toll. That's both in Gillespie City of New York, as well as Plummer v. New York City Health and Hospitals Corporation. And that's what we have here, a voluminous medical record describing many interactions, but not documenting those particular appointments that, according to plaintiff's 50H testimony, he attended. Even plaintiff's own medical expert opines that where there's a lack of documentation of an event in the medical records, that's evidence that such event did not happen. You can see that in R227. But the second point is, even if plaintiff's testimony were credited, that still would not establish a course of treatment. Because again, what he's describing is at worst a discrete examination where he was allegedly misdiagnosed. These providers that he allegedly saw, the ones he can't identify specifically, they didn't prescribe medication. They didn't give him any over-counter treatments. They didn't tell him to change his diet. They didn't recommend any diagnostic exams. They didn't schedule any follow-up visits. They didn't do anything to indicate that they thought this was an ongoing relationship. And at the same time, plaintiff himself's behavior, as he describes it, does not indicate he viewed this as an ongoing effort, because he claims to have returned to the emergency room each time he had some concern. He never testifies to going to the same clinic or practitioner to provide consistent care, a consistent ongoing effort to treat something, which is the hallmark of the continuing treatment doctrine.
So, counsel, this is Judge Scarpula. Is what you're saying that he may have thought there was treatment, but there's no evidence that the doctors thought there was or that the doctors treated it as continuous treatment, and you need to show both, right?
Well, you're certainly right that you need to show both. And our argument is that there's really neither in the record.
Neither, okay.
The positions, but even if you look at Mr. Viniello's testimony about what he says happened that's not in the medical records, that contradicts the idea that he thought there was such a relationship. He says he was told it was hemorrhoids and that he can show up in 6 months again if it's worse. He doesn't do that. He doesn't go back to the same providers, the same clinics repeatedly. The only thing that plaintiff says in his testimony is that he uses the word monitoring. He claims this was a monitoring relationship. That's just a conclusory statement. What he's describing is not monitoring.
You'll have time on rebuttal, sir. All right, let's hear from plaintiff's attorney.
Good afternoon, Your Honor. It's Brian Isaac. I represent the plaintiff respondent. I think the problem with my adversary's eloquent argument is that it kind of imposes a kind of a quasi-duty on the part of the plaintiff to actually practice medicine. The linchpin of this case obviously goes to the scheduled August 14, 2013 colonoscopy. And Justice Singh, with respect to some of your questions, I just wanted to give you the pages because, as you know, on 190, we have a CD, but we don't have the pages. I actually have the pages. The term that they used in the hospital was, quote, lost to follow. That's as early as 10/3/13. That's 481 on the CD. 534 was what you referenced, where they said surgeons agree to follow up on these issues. And on 6/12, it says, I'm just going to read it. It's kind of hard to interpret. Of note, OT note, PT was previously evaluated by GI. 7/13, where painters had similar SXs. I think that's complaint. RECC referred to have colo. I think that's a colonoscopy. But plaintiff lost the follow-up. And I think our expert, Dr. Finkel, both in the late claim application and in the affirmation in opposition to the motion for summary judgment, said something that I think was telling and I think is true. Where you have a potentially lethal condition with someone who's not medically sophisticated, let's be clear, the plaintiff isn't a medically sophisticated person. He's 52 years of age, never had a colonoscopy. His maternal grandmother died.
I hate to stop you, Mr. Isaac, but here's my question to you. You're talking about the underlying malpractice, your theory of malpractice. And I guess what I'm having trouble with, and maybe you can square it away from me, is let's assume you're right on the malpractice. The question is the continuous treatment. And if your theory of malpractice is that the hospital didn't follow up, isn't that inconsistent with continuous treatment tolls?
Yeah, that's what my adversary says. We cited to actually the best case is your decision against Lewis against Rutkovsky, Rutkovsky. It's 153 AD3D 450. The good thing about the decision isn't that I think it favors me. There's also a dissent, which kind of takes the city's position as well, which I think helps me. And I think what this court held is that a medical provider doesn't get a pass in a failure to diagnose case. The issue is, should you treat the symptoms, not how you phrase the symptoms? And I think that's what our expert said not once but twice. And I think that's what the case law says as well. There's no question that the plaintiff was lost, and there's no question that there was no proper diagnosis made here. And I would point out that if you look at the medical records, as I know you did, it's striking to me that where they put in PMI, past medical history, or PMH, past medical history, almost every single entry has the same thing. Remarkable, right? Diabetes mellitus, which he had, HTX, hypertension, which he had, but there's nothing about a potential cancerous condition that could kill someone. And according to our expert, until I think November of 2015, that was the first time that somebody actually looked at the records and said, oh, we might have a problem with regard to this situation. So I certainly agree with you that there are issues of fact that are present here. But again, this is a summary judgment motion, and a deficiency in the papers always cuts against the movement.
So I'm sorry, Mr. Isaacs, I still haven't heard an answer to the question. Is what is the continuous treatment here? That just to just be specific and tell me what treatment.
The treatment was the colonoscopy to deal with the rectal bleeds that according to,
I'm sorry, that's colonoscopy is a treatment?
The colonoscopy is a procedure. So the procedure is a diagnostic procedure. It was supposed to be held on, so let me give you the date, August 14, 2013. Plaintiff's testimony is on page 100 to 110 of the record, where he said he called the day before, was told they were overbooked, called back, couldn't get an appointment, and then went back and was told by a physician that it shouldn't have been canceled, but that he would be contacted. Now, the defendants do say that that's not in the medical records, but I don't know of any case which talks about the primacy of medical records. Something being there or not being there is an outcome determinative on a summary judgment motion. And here we are dealing with a diagnostic test that presumptively would have shown some lesion, certainly not stage 4 adenocarcinoma.
So I'm sorry. So the only treatment you're saying is that there should have been a colonoscopy in 2013, correct? Is that right? So in the 2 years, you agree in that 2-year period, all that happened was that was the procedure with respect to the cyst.
Yes. Correct? In other words, yes, correct. Just let me be clear. So he went in with complaints of rectal bleeding, had the colonoscopy. Then was supposed to have the colonoscopy, didn't have the colonoscopy. In 2014, it's at 542 to 575 of the CD. The visits did not they related to the hydrocele, not to the rectal bleeding. And then from September 4, 2015 to December 28, 2015, he really presented with massive bleeding, which ultimately led to the inoperable adenocarcinoma. And Justice Singh, just so you're clear, that's 576 to 728 of the CD. So our position.
Mr. Isaac, this is just our thought. So we're clear, we all agree that there was no treatment between 2013 and 2015. There just wasn't.
That's correct.
So
that's correct.
If we say that you need to have some treatment to have continuous treatment, you disagree with that?
I don't, but the failure to follow up on monitoring that should have been done can be continuous treatment.
You're saying that it's the hospital's medical obligation. That's the continuous treatment. I'm not really clear how it's that if that was their malpractice, it happened in 2013.
No,
how could there be continuous treatment when they didn't? I still don't get it.
So the plaintiff's testimony, Your Honor, was, and again, that's why I cited, I'm sorry, I'm going over my time, Justice Gish. Can I just answer
I'm not stopping you because it's in response to one of my colleagues' questions.
I try to stay to my time, though.
I know you do.
The plaintiff's testimony was specifically at 100 to 112 that he himself called, it was canceled, and he was told, and it was his impression that it would be rescheduled. Again, I'm not suggesting anything was done because it wasn't, but let's assume that it was undisputed that the hospital said to the plaintiff, we'll let you know when that comes back. That's still continuous treatment, and it is undisputed on this record, unlike you or I who have private insurance, that Bellevue was his not only primary care physician, but only care physician. So there was discrete treatments, but I think there's certainly enough here factually on a summary judgment motion to invoke the continuous treatment doctrine, especially given the records as written by the Bellevue Hospital staff itself.
Okay.
I'm sorry for going over my time.
That's okay. Mr. Townsend.
Yes, thank you, Your Honors. With regard to the point about that there is no case that indicates the primacy of medical records, that is the Ganes case and the Plummer case, both from the Court of Appeals. In both instances, where a plaintiff said, outside the medical records, I have a recollection of some vague recollection of some form of appointment or treatment, the Court of Appeals said that does not overcome the lack of such evidence in the medical records.
So let me ask you what I asked Mr. Isaacs. How do you reconcile, or can you reconcile the malpractice, which they're claiming was a failure to follow up with a continuous treatment. Aren't they antithetical?
Justice Gish, I really believe they are antithetical. And what that means is that even if this court thinks that the appellant committed malpractice in 2013, those claims are untimely. It may be a strict rule, but that's the rule that the Court of Appeals articulated both in Nykorchuk, for example, as well as the Young case. And in the Young case, for example, the hospital or the particular clinic had a mammogram indicative of cancerous a presence of a cancer or some sort of abnormality, and failed to alert the plaintiff. And even that, which again may have been malpractice, or the plaintiff would argue as malpractice, still did not create a course of treatment. Where there's a failure to diagnose and a failure to establish a course of treatment, this doctrine cannot be invoked. The case that Mr. Isaac cited to Lewis v. Rubutsky is a case where there was no correct diagnosis, but there was an effort to treat. The defendant physician was doing something.
Oh, so I think Mr. Isaacs would respond that there was treatment here because there was a colonoscopy scheduled for 2013.
I think a diagnostic procedure by itself is not an established course of treatment. That's a diagnostic effort. There's no, again, recommendation. There's no proposed treatment. Again, the Court of Appeals has held that diagnostic exams by themselves do not establish a course of treatment. And at worst case, even if that were a start of a course of treatment, it lapsed. It didn't continue. It wasn't an ongoing course of treatment carrying the plaintiff into the timely period within the statute of limitation.
Okay.
Thank you, Your Honor.
Anything further, colleagues? Thank you. Thank you both. All right, the next case is LeBrew against Vance.
Yes, Your Honor. Lawrence LeBrew for the state of New York on behalf of Marvin Hayes. I got disconnected before, but I'm back. I've also got...
We're glad to have you back, Mr. LeBrew.
Did I get 2 minutes for rebuttal, Your Honor?
You did. You got 5 and 2. Go ahead.
Okay. May it please the court, Lawrence LeBrew on behalf of Marvin Hayes. Your Honor, this is basically a writ of habeas corpus seeking release pursuant to 3032. There's a threshold subject matter jurisdiction question here, and there are basically 4 dates in question. On jurisdiction, our position is that the lower court had jurisdiction to entertain the writ for release pursuant to 3032, pursuant to the statute 7002B5, and also pursuant to holdings by the Court of Appeals and the Appellate Division.
Let me ask you a question, because I was a little confused procedurally. Was the issue of the speedy trial after it went before Judge Bybin, did Judge Pickles rule on the writ separately on the 3030 aspect, or did she just rule on the COVID-19 aspect of the writ?
The issue was presented to Judge Pickles. If I can quote her from the record, she said specifically, I'm not going to touch that. And I'm presuming she was relying on law of the case since another Supreme Court justice had made a ruling on it. And I'm assuming that was her basis.
You had a right to review under the Court of Appeals authority, the Chacwin versus Warden, right?
Yes, Your Honor.
That allowed you to do that. So now it's up here, and now we have to decide. We got the appeal from Judge Pickles, and the question about the 3030 aspect of the writ, we can decide that, right?
Yes, Your Honor, you can decide that. In fact, when we went to Supreme Court with an order to show cause that the judge exercised her discretion not to sign the order to show cause for 3032, we came to this court under the court's original jurisdiction under the statute to hear the writ.
We threw it back, right? We threw it back to the Supreme Court.
Yes, right. Right, you threw it
we
back.
like to see what they do at the trial level, and then we look at it and go, right. So now, right. So I think the issue is really properly before us. I speak for myself, but I think we're okay. I'm okay with the jurisdiction. I think we have jurisdiction.
Okay, Your Honor. And just for the record, the Attorney General was actually served pursuant to the court's instructions on May 4th. The Attorney General informed the lower court that they weren't going to participate in this proceeding. And they informed the court and all the parties, Your Honor. That was Assistant Attorney General James Cooning. With regard to the dates in question, basically there are 4 dates. The first date that's at issue is the date the defendant was arraigned, or the petitioner was arraigned, on 21 August 2019. Our position is that he was committed to the custody of the sheriff when he was arrested. There's a split in the lower courts on this issue. Within the first department, different Supreme Court decisions have come out differently on this issue. In the second department, they're saying that it starts when he's arrested. Some cases in the first department are saying that the statute says committed to the custody of the sheriff. Our position is that when he was arrested, he's in effect committed to the custody of the sheriff.
So that's a +1 day for against the people, right?
Yes, Your Honor.
Okay.
The next date in
Go ahead.
The next date in question is the decision after the omnibus motion. That's that August 28th date to September the 3rd date. Our position is that date is chargeable to the prosecution for the simple fact that the people were in a pre-readiness position. They had never announced readiness for trial during the duration of the case. They didn't announce readiness for trial before he was arraigned on the indictment and the motion schedule was set. They did not announce ready for trial after the decision on the motion, and the next court date after the decision on the motion, they did not announce ready for trial. Now, we submit that the cases cited by the people are not on point on this issue because those cases deal with post-readiness delay, and we're in a situation where we're dealing with pre-readiness delay. The appellate division has spoken on that issue, People versus Enswood, and our position is that People versus Brown and People versus Rodriguez further established the fact that that period after the decision on the motion is not chargeable to the people. There's also the additional factor that.
Yeah, Mr. LeBrun, you have run out of time. I'll give you a few more minutes because I know there's some additional periods that you want to just bring to our attention, but I'm going to ask you to be efficient. Go ahead.
I will be efficient. We're saying that the date from 30 January 2020 to 27 February 2020 is chargeable to the people because their statement of readiness was illusory. And we're saying the date from 4 March 2020 to 17 March 2020 is chargeable to the people because defense counsel was not engaged in any other action. Defense counsel, which was me, appeared on every date in the court proceeding. Counsel always have counsel. We never made motions that were excludable or said we were going to make a motion that would be excludable. Therefore, we believe that the defendant.
Judge Biden said that I don't know if it was you, but that defense counsel was in a multi-party case someplace else actually engaged. That wasn't true?
That was true. I appeared in that court on that date. I was actually engaged in federal court in Newark. However, we were off that day, so I appeared in court. Okay, so I was actually there for the record for everything that happened in court.
But you couldn't go to trial because you were actually involved in another case, right?
That is true, but the people couldn't go to trial either because they weren't ready because their statement of readiness was illusory. That's our position.
Okay, thank you.
You're welcome.
All right, we have Mr. Croy.
Yes, Your Honor. Good afternoon. I'm John Croyce for Respondent Mr. Vance. May it please the court. Just to start with the jurisdictional issue real quickly, there is no dispute on this. The people concur that this matter is properly before this court. And in fact, it is our position that Justice Pickles did rule on this. She mentioned that she reviewed all of the documents from below. And the reason, Your Honors, that the record appears as it does is because there had been from petitioner's initial petition, there had been a supplemental petition filed about COVID specifically. That's why the parties discussed COVID exclusively.
No, I understand, but she didn't say anything about the 30-30 in her decision. Did she? I mean, maybe it was in front of her. She didn't say a word about it. I looked and I looked.
She did not address the substance at all, but our
Okay.
position, Your Honor, is that by saying that she reviewed everything and by denying, she was denying.
In any event, you don't disagree with Mr. LeBrew that we have jurisdiction to look at the 3032 issue, right?
That's exactly right, Your Honor.
Okay.
We do
All
not.
right. I think enough said on that. Let's talk about the merits.
Yes, Your Honor. So to go through the periods, we count 5 periods that are in disputes. This is on page 14 of our brief. We have a chart breaking them down. We count 87 total includable days to the people. The first period of dispute is August 22nd to the 27th. That dispute, as my colleague brought up, relates to what remanded to the custody of the sheriff means. We cite a couple of this court's cases, including saying that remand to the custody of sheriff.
Again, that in and of itself is really just make weight. Why don't we go on to the other periods, which really make a difference here?
Yes. So the next period is October 28th to December 3rd. That period was excludable regardless of the people's readiness because it was necessary time to prep for hearings that had been granted at defendant's request. There were multiple hearings being prepped. There were witnesses that needed to be prepped for them. We were given roughly a month to do so. The authority for that is People v. Green. The third period is January 30th to February 4th. This is the period that relates to the certificate of readiness that was filed off calendar. And as I understand my adversary's argument, relates to his claim that the certificate of compliance with the new discovery rules was itself done in bad faith and illusory, rendering our certificate of readiness illusory. Now, Your Honor, that is not the case. What happened in this case is we made 4 disclosures prior to the off-calendar certificate of readiness. We filed the off-calendar certificate of readiness on February 3rd, planning to go to trial with 2 witnesses. But however, a month later, on February 26th, I'm sorry, we planned on going forward with 1 witness, Officer Smith. On February 26th, Officer Smith became unavailable for hearings and trial, and so we had to substitute 2 other police witnesses in his stead. That very same day, we sent defense counsel all of the relevant Garrett and Giglio materials. He'd, of course, already received all of the other disclosures factually he was entitled to on 4 separate occasions. And then the following day, we provided him hard copies of those disclosures. So, Your Honors, the bottom line here, I think, is that this is a situation resolvable by People v. Brown, which is that a certificate of readiness is a statement of present readiness, not of future readiness. When we filed our COR on February 3rd, that was filed with Officer Smith there and available, and with us having given over the defense all of the disclosure material that he was entitled to. And I would point out, Your Honors, that the very next day we stood up and announced ready in court, which brings us to our 4th period, February 4th to February 27th. That period, Your Honor, has, as I read the record, nothing to do with whether counsel was engaged. That was a matter of counsel having requested additional time, which was granted. It's a very short calendar appearance, but it literally is just a request for extra time and granted, excludable as defendant's request. And then the period, the final one that I have here is from February 27th to March 17th. That is excludable for 2 reasons. The first is that that is the time when defense counsel was engaged in Newark. Defense counsel's engagement on another case renders trial impossible, obviously, and as a result, that time is excludable regardless of the people's readiness. That time is also excludable, Your Honors, for the separate reason that as Judge Bybin warned counsel when he attempted to bring, he sought a habeas petition as opposed to taking advantage of the immediate 3030 hearing that he was entitled to. She warned him that the delay to figure out whether that procedure was the correct one would be attributable to him. So for those 2 reasons, that period is also excludable, which by my count, Your Honors, brings us to 87 days, which means that his rights were not violated. If Your Honors have any questions about any of those specific periods, I'm happy to answer them. Otherwise, we would rest on our briefs.
Any questions? Okay. Mr. LeBrew, 2 minutes.
Briefly, Your Honor, with regard to 4 March 2020 to March 17, 2020, in the record, I filed a notice with the court and as part of the original record, letting them know that I was no longer engaged in Newark and that I was available on trial. So that was filed on the 4th. So our position as 4 March 2020 to 17 March 2020 is chargeable. With regard to discovery, Judge Ward made an order for them to turn over certain documents. I made a specific request for certain documents. The new law under CPL 245.20K and 245.53 required those documents. Those documents were central to the case. They involved the officer who conducted an inventory search who had serious credibility problems, and that could have affected the outcome of the case. With regard to the people's readiness, the new statute makes void the assumption that the people are automatically presumed ready. Okay, so
let me just ask you a question on the discovery issue. So it's your position that under the new law, regardless of whether they were calling new witnesses, they needed new police officers, that you should have gotten this discovery under the new law earlier?
Yes, Your Honor.
Regardless of whether they were called or not?
Yes, Your Honor.
And therefore, they couldn't say that discovery was complete and they were ready?
Yes, Your Honor, because this is the officer that signed the felony complaint. This is the officer that conducted an inventory search at the precinct where he said he recovered a knife. And this was the officer that was part of making the arrest. That's the information that the people gave me. So that information was critical regardless of who they called, because at a hearing, we were going to have a hearing on those issues.
Okay.
Also, at a trial, those issues will come up also.
Okay, your time's expired. Thank you, Mr. LeBrew. Thank you both.
Thank you for it.
Okay, the next case is People versus Jonathas. Jonathas. I'm sorry if I mispronounced that. You can proceed.
Your Honor, good afternoon. Thank you. My name is Peter Tillum, and I represent Mr. Jonathas, who is a licensed nurse in the state of Massachusetts. He was also a licensed gun owner in the state of Massachusetts, and he was a passenger in a vehicle in Manhattan within the 32nd precinct when his car was stopped for allegedly rolling through a steady red light. That ticket was ultimately dismissed, but there were two weapons found in the car. One was Mr. Jonathas's lawfully possessed weapon in the state of Massachusetts, and another one was in the waistband of another passenger. Mr. Jonathas was seated in the back seat of that vehicle, and what should have been a routine traffic stop turned into an event where each person, included, starting with the driver, was taken out of the vehicle and systematically either questioned or patted down.
Well, the taking out of the vehicle, that's allowed under People versus Garcia, right?
That is allowed.
The real issue for us is whether there could have been an inquiry about the weapons without it rising to a level 2 stop, right?
That is correct. And the Court of Appeals answered that question in People versus Garcia, and the answer is clearly no. And the fact is that the Garcia case dealt with this specific issue. Is nervousness enough to justify a level 2 inquiry? And unquestionably, this
is Judge Singh, Counselor.
Yes,
prior to Sergeant Martinez's questioning, his inquiry, how about the inquiry with respect to the driver, where there was some hesitation, some references, check with someone else? Would that be sufficient?
Well, no, Your Honor. In fact, Justice Singh, I think the people made clear in their brief that what the officers were relying on was nervousness of the driver. They cited the word.
No, I understand that, but didn't the driver of the vehicle sort of reference somebody else? Check with, I'm forgetting the name. Check with Mike, or there was some reference with respect to that response. Was that sufficient then for the sergeant to make further inquiry?
Well, so Your Honor, to answer your question, that question was asked at the back of the car, and the driver was asked at that point with no reason if there were any weapons in the car. So that was already a violation of the Court of Appeals holding in Garcia. But then,
so in other words, right? Just so that we're clear, that response, that evasiveness, was in response to the question, which we have to figure out if they could have asked in the first place.
Correct, Your Honor.
Okay.
And correct. So there were at least two inquiries about weapons in the vehicle. One was at the back of the car. And again, Justice Gish is completely correct that there's nothing wrong with taking the driver out of the vehicle. But when they take him out of the vehicle, there is no reason to start asking him pointed questions. There's no reason for that level 2 inquiry at that point. There was mere nervousness.
How about, Counselor, how about the fact that the officers believed that people in cars with out-of-state plates are bringing guns into New York? Would that be something that would be considered?
I would think that a determination by a court, by either a Supreme Court justice or this court, that it's open season on people with out-of-state plates is not something that the court wants to do. Now, it may be that certain states, and I think a more narrow holding, certain states may be states that where people may possess guns because gun laws are looser there. Massachusetts would clearly not be one of those states. Massachusetts has some of the tightest gun laws in the country. And so if it was, maybe this would be a more appropriate discussion if these were Texas plates or Florida plates or someplace where the gun laws were more loose. But to simply say that everyone who drives a car with out-of-state plates, someone with plates from New Jersey or Massachusetts or Connecticut is automatically subject to a level 2 inquiry, I think is not something that would be appropriate. There's certainly no evidence that there's any level of trafficking of guns from those states, and there's nothing in the record that would support that, Your Honor. I would further mention, and I just want to be very clear, in their brief, the people used the term nervous 22 times. They used the term nervousness 17 times. They used the term stammering 9 times and stammered 1 time. They used sweating 6 times. These were all physical manifestations of nervousness, which is exactly what the Court of Appeals said you cannot rely on to get to a level 2 inquiry. So I think it's very clear that Judge Marchand misapplied the DeBoer case, and he did not go through a proper analysis. He kind of went through this very amorphous totality of the circumstances. He never really discussed where we were on the level on the DeBoer inquiries.
Let me hear from your adversary.
Thank you, Your Honor.
Ms. Reagan?
May it please the court, Amanda Regan on behalf of the people. The hearing court's decision denying suppression of the gun recovered from the defendant was entirely proper. After observing the car drive through a steady red light, the police conducted a lawful traffic stop, and while questioning the driver...
Okay, so counsel, let me stop you there for a second. So the police officers asked the driver to come out. What did the driver do? Was he uncooperative? Did he not answer questions? Did he refuse to show his license? Or did he even act in an extremely suspicious manner that might have triggered further inquiries?
Well, first, I just want to point out to your honors that the defendant doesn't even have standing to challenge the questioning of the driver in this case. He has no reasonable expectation of privacy in the questions posed.
But that's not the issue, right? Because if was it Larson who made the first inquiry with respect to the driver? If that wasn't proper, then how could Sergeant Martinez then inquire with respect to guns in the vehicle with the passengers, including the defendant?
Well, putting standing aside, it's still our position that the defendant doesn't have the standing to challenge that inquiry, but putting that aside, the police questioning of Luigi, the driver, was completely proper. Here, it's more than just nervousness. Arguably, everybody is nervous when they're stopped by the police.
I'd be nervous if I was pulled out of a car by a cop.
Here, there's extreme nervousness, and there's 2 cases that we cite to in our brief.
Can we really turn, does the Garcia analysis really turn on whether you're nervous, just plain old nervous, or extremely nervous? That can't be, right? You'd concede that. That can't be
it is relevant, but there is more here. There are many more.
Let's hear the more, and let's see if the more is enough. Because Garcia said you needed more than nervousness. And,
Yes.
and honestly, I don't think we're going to start qualifying degrees of nervousness to figure out if Garcia is complied with or not. I think that's untenable.
Understandable, but beyond nervousness and the physical indicia of nervousness here, the driver was unable to answer simple questions posed to him by the officers.
Like what?
The officers were asking him, where is he coming from, what he's doing in the area, where is he headed, and the officers...
I didn't see that in the judge's decision, that they were evasive about answering the questions.
It wasn't that he was necessarily evasive, Your Honor. It was that he provided inconsistent responses, and those...
I didn't see that in Judge Merchan's decision either. I didn't see that finding. I did see, what I did see is on page 23 of the decision is that the court looked at the factors in addition to nervousness that it was relying on in finding that it was a reasonable level to stop, the criminality was afoot, right?
Yes, and that
Right.
was that.
So let's look at those things. Let's look at those things. So the first thing the judge said was a lawful traffic stop. Well, that can't be the basis because these are always, Garcia situations always have to be pursuant to lawful traffic stops, right? That's always present in every one of these cases. Okay.
Yes, Honor, but it's also a violence-prone location where there had been an increase in shootings.
So every time there's a high crime area, we assume that somebody there's criminality afoot if they're nervous in a high crime area?
No.
Okay. Just wanted to know. We're on the same page.
The circumstances.
Let's talk about the Massachusetts plate. What, if anything, does that have? How does that bear into this? Because the judge did rely on that. How does that figure in?
The Massachusetts plates, it alerted the officers that perhaps there was, it was one of the factors that drew the officers' attention to the car initially, and they were driving behind these plates. And all the officers testified that it is common for for individuals to use cars with out-of-state license plates to traffic guns.
Okay, so let me stop you there. As your adversary raised, the Massachusetts gun laws, he says, are very strict. Frankly, I don't know. Wouldn't the detective have to know, and he acknowledged he didn't know anything about the Massachusetts gun laws to make that assessment?
I think it's untenable to require the officers to know the gun laws of all 50 states.
So wouldn't you think it's actually also untenable that people are stopped because they're from out of state, because police officers think that they're carrying weapons?
But that's not the reason he was stopped here. He was stopped here because he committed a traffic infraction.
Right, but then you make the next level inquiry as to, do you have weapons? And that's based on out-of-state license plate.
But it was based on more than just the out-of-state
license plate, high crime area, and nervousness.
And the fact that this was an area where had been an increase in shootings. There was a basketball program going on at Rucker Park, so it was a very crowded area.
So what you're telling us is that if this had happened, if this traffic stop had happened on the Upper East Side, because it's a low crime area, and maybe someone had Jersey plates, there would not have been that extra level and of indicia to ask about the weapons. I mean, you can imagine how that just doesn't play well.
No, and I understand the court's position, but that's not all that was here. And you also have to understand.
Lower court. All we can do is look at what the lower court said, right? You can argue what the lower court said was nervousness, out-of-state plates, and high crime area. So high crime area initially, how could we? So that would mean if it was on the Upper East Side, there wouldn't be that extra indicia. That doesn't sound right, right? And out-of-state plates, if this was a Jersey plate, would that? I mean, there are as many Jersey plates as New York plates driving around Manhattan and the Bronx. So neither one of those sounds like something that would justify, in addition to something that we all agree isn't enough, to justify the stop, to the inquiry about the guns.
Your Honor, there was more here as well. These officers had, and the court notes this in its decision, over 33 years of experience, and they were all intelligence officers within the 32nd precinct. And the court said in its—
So what does that mean, though? That doesn't mean that I mean, the whole purpose of the DeBoer analysis was that we weren't really going to be relying on law enforcement's kind of gut intuition. I think a crime's being committed, that there has to be some outward indicia that would lead to a reasonable suspicion that criminality was afoot. So I whatever. All right, you know what? I'll let you make a final statement. Your time is really up, and then we'll hear back from Mr. Tillum.
Your Honor, I understand the court's position. Again, I just want to reiterate that the defendant does not have standing to challenge the questioning of either Luigi or Joseph, the other passenger with the gun. The people have preserved this issue. They objected twice during the hearing, which is on page 536 of the record. And I just point the court to People v. Ladson and People v. Myers on page 43 of our brief. This issue is preserved and the defendant doesn't have standing. Thank you.
All right, Mr. Tillum, your rebuttal, and can you please address that issue of standing?
Yes, Your Honor. First of all, the people really addressed this for the first time in their appellate brief, in their opposition brief. This was never raised below. There were post-hearing memoranda. The people never raised this issue. But despite that, despite the fact that it's not preserved, I want to be very clear. It was Mr. Jonathas whose movement was impacted by this illegal questioning of the driver. The driver was pulled out of the car and subjected to level 2 inquiry, while Mr. Jonathas was not free to leave. He was a passenger in the car, and it was his movement that was being impacted. Of course he has standing to contest this. He was in the vehicle when Sergeant Martinez is asking all of the people in the vehicle, are there any weapons in this car? So he clearly has standing to contest the illegal questioning and the illegal activity that occurred. The people raised the issue that that the driver was unable to answer simple questions. There's nothing in the record to support that. I would also note that while the judge considered Rucker Park to be a high crime area, I would note, I believe the testimony is this was during the day. This was, as the people mentioned, there was a basketball tournament going on. This was not a high crime area. This is a famous park where people play basketball. And so for all those reasons and the reasons we argue in our brief, I think it's very clear that Judge Mershon misapplied the law. And in this case, the firearm that was recovered from Mr. Jonathas must be suppressed. I thank you, Your Honors, for your time today. If you don't have any questions, I'm done.
Okay, I'm seeing head shake no, so the answer is no. Thank you very much. Thank you both, counselors.
Thank you, Your Honor.
Okay. The next case is 111 West 57th Investment versus 111 West 57 Mezzanine.
Good afternoon. My name is Stephen Sinatra. I'm with the law firm of Greenberg Chorig, counsel for 111 West 57th Mezz Investor LLC. The core facts underlying the amended complaint in this appeal are the same as when we were last before this court in January of 2019. In January of 2017, the $725 million debt stack for this project was in default because the loans were out of balance by over $57 million.
Counselor, this is Judge Singh, Counselor. Can we get to the merits of this? And can we deal with the issues here? And the first issue is waiver of fiduciary duties. Why is plaintiff not correct that Section 8.5 doesn't in any way preserve fiduciary duty claims, at least with respect to bad acts, which is contained within that provision?
Well, thank you for the question, Judge Singh. I think the case law makes clear that what is being done in Section 8.5 is a waiver of all fiduciary duties, and Delaware courts interpreting language that's relevantly similar to that language has interpreted the language as a waiver of all common law fiduciary duties and has preserved under this language only contractual duties. So the question then arises, well, what does it mean then when there is a reservation for fraud, intentional misconduct, and intentional misconduct and breach of law. Well, what it means is these are not acts that can be waived. They're torts. They are not fiduciary duties. The clearest way to illustrate that would be, it doesn't require that there be a fiduciary relationship between parties in order to have the obligation not to commit fraud, not to breach the law. Clearly, and what Celestial has said, and the Wensky case has said, and Fisk has said, that language is not an attempt for the parties to revivify, to bring back some fiduciary duties, which language like this clearly indicates is not intended to retain any common law fiduciary duties.
If you're correct about that, then why wouldn't Section 8.6b then be a basis for liability?
One has to distinguish two things. One has to distinguish between liability and duties. Okay, what the Delaware courts have done is distinguish between a clear attempt to say, except as otherwise expressly provided in this agreement, none of the members shall have any duties or liabilities to the company or any other member. And then it says, including fiduciary duties. It's even broader than the waiver that was in Celestial. And what it goes on to say then is reserve liabilities for things that can't be waived at all. So B is in no way a modification. And that's just not to say that there aren't duties that are set forth within this agreement. They are not fiduciary duties. They are contractual duties. That is another way in which the court has been very clear in interpreting this language, that under Delaware law, the parties are free to expand, limit, eliminate common law fiduciary duties. That is what has been done here. And that is where the court erred. And by the way, this is exactly what it is that Judge Branston held in the companion case, where there was a litigation between investment and sponsor. Judge Branston explicitly and expressly held that this language is a waiver of all fiduciary duties.
Okay, so if you're correct about that, the misconduct, as I understand it, is a failure to object to strict foreclosure. Would that fall within the contractual enumerated bad acts? Well,
that is a question of whether or not it's a breach of contract. There's no such thing as aiding and abetting a breach of contract. The claim that was sustained here by Judge Sherwood was aiding and abetting a breach of fiduciary duty. It's simply not possible. Then the question becomes whether or not under the UCC there was some bad act here that would prevent us from having consummated a proper UCC strict foreclosure. And there is no evidence of that.
So the bad act here, according to the plaintiff, is a failure to object. And as a result of not going to a public auction, they lost a substantial amount of their investment. But why isn't that a bad act?
I think we have to distinguish between a bad act and what they claim is a breach of contract. They can claim that it's a breach of contract, but that doesn't involve a claim against the lender. The lender stands in a debtor-creditor relationship with this borrower, and it has the ability to move forward and exercise its rights pursuant to a strict foreclosure. If there is some sort of breach of contract that exists.
But if there's a side deal made by the lender and the sponsor's principals that we're not going to object, and oh, by the way, you will remain the manager, and we're going to give you an interest, could that be considered a bad act?
No. Think about the words that are being used in the context of this complaint. They're the litigation hyperbole, bribery. Bribery essentially involves, that's a bad act, and it essentially involves paying someone for something that they're not entitled to.
But that's what they're arguing here. That's what the plaintiff says you're doing.
They are and they're not. They're not in a key way here. The Delaware courts have made clear that where a change in management retains the existing management, or a change in ownership retains existing management, that's not to be viewed with suspicion. As a matter of fact, it's even quoted in our papers as a routine occurrence and should not be viewed with suspicion. So our considering having put in $82 million of an investment, $25 million to purchase the junior mezz interest, and over $57 million in order to cure the imbalance in the loans, keeping on management in order to protect that investment doesn't smack of a quid pro quo. And I would like to quote Justice Gish when these allegations are.
I'm going to stop you because you're out of time. You don't have to quote me. Okay. All right. We understand your argument. I'm being glib. It's okay. All right. Let's hear from your adversary. All right. Ms. Proctor.
Thank you, Your Honor, and may it please the court. Haley Proctor on behalf of the plaintiff respondent cross appellant. The defendant was a lender, and as such, defendant's only right was to get its money back. Once plaintiff obtained a TRO halting the strict foreclosure process, there was no innocent explanation for defendant's failure to proceed with a foreclosure auction. Defendant didn't do so because defendant didn't want its money back. It had just purchased the note at face value. Recouping the debt would be money in, money out, and hardly worth the trouble. No, defendant had purchased the note because it wanted to own the property.
We understand that your client at least is claiming that they lost a substantial amount of money, but that we have to put this in the rubric of what's available to you in terms of causes of action. Your first appeal your first claims which sought to stop the strict foreclosure, that's ancient history. So we don't need to talk about TROs or preliminary injunctions. Now you're suing for money damages. And the question is, do you have causes of action that will support that? Go ahead.
Yes, Your Honor. And Justice Sherwood properly held that the allegations that I was just describing, and specifically the fact that defendant went to the two men who control the borrower and said, we'll give you equity, we'll give you fees if you prevent the borrower from objecting to the strict foreclosure, that those allegations suffice on a 3211 motion to state claims.
Right, and what cause of action do they support? What is it, a breach of contract? Is it a breach of, what is it? What is it in claims world? Right.
3 claims were upheld by the court below. One is a claim for a breach of the UCC's good faith requirement. That's a statutory claim. The second is a claim for aiding and abetting a breach of fiduciary duty.
Okay, so let me stop you there. So that's where we go into the analysis of Section 8.5. It seems to me that under Delaware case law, you do have a tough argument here. That what's served is contractual duties, right? I mean, contractual liabilities, but you've given up your claim for fiduciary duties, correct?
Your Honor, we do not believe that that is the correct interpretation of Section 8.5. I think the dispositive point here is that Section 8.5 goes on to define the duty of care. There would be no...
Stopped working. Please come by.
There would be no duty of care to define if all of the fiduciary duties had been waived. Moreover, if in fact the defendant were correct that there was no fiduciary duty of loyalty, that would eliminate or limit liability for intentional misconduct, which is specifically what 8.5 disclaims. This provision is distinguishable from all of the cases that defendant has cited here. And those cases, in fact, acknowledge that it is possible for fiduciary duties to survive these sorts of provisions, that Winsky specifically calls them contractual fiduciary duties, and that aiding and abetting claims can exist for these sorts of fiduciary duties. In every case that defendant cites, there was a complete waiver of fiduciary duties. And the language of intentional misconduct...
But that's what the language in 8.5 says, is that you're giving up any duties or liabilities to the company, including fiduciary duties.
The language of 8.5 is qualified. It says that, but then it says, provided, however, this provision shall not eliminate or limit liability.
Liabilities. So doesn't that, according to Delaware case law, then become a contractual liability?
No, Your Honor. In all of the cases that in which they found a contractual liability, the language is distinguishable. So let's take, for an example, the Celestial RX. The waiver provision in that case said, notwithstanding anything in this agreement to the contrary. So separate language qualifying the exculpation clause in cases of intentional misconduct was held not to recognize the existence of or revive breaches of fiduciary duties. Here, our language says, except as otherwise provided in this agreement, and then goes on to say, provided that there liability for intentional misconduct shall not be eliminated or limited. And and then it goes on to define the duty of care, which again doesn't make any sense if all fiduciary duties have been waived. That is recognizing the continued existence of a fiduciary duty. In addition, Justice
Counsel, this
Branston,
is Judge Scarpula. So basically what you're saying is you've disclaimed fiduciary duties except you haven't. And that makes no sense, seriously no sense. You either disclaim them or you don't. But you can't disclaim them and say, but actually you don't. So if you're asking us to interpret the agreement that way, that's a hard sell.
Your Honor, the proviso we're not claiming that the proviso revives all fiduciary duties. So take an example of a common duty of loyalty that would remain waived by Section 8.5, the corporate opportunity doctrine. So Stern and Maloney could go across the street and invest in a competing condominium development project, and we would not be able to sue them for that. But where they engage in intentional misconduct, or where they engage in unauthorized self-dealing in violation of the parties' agreement.
Well, okay, so let's talk about self-dealing. Why is that not explicitly covered by the breach of, that's not fraud. That's not, I assaulted you on the property. That's not covered by any of this alleged carve-out that you're talking about that is a fiduciary carve-out. And even that's not a carve-out there.
We disagree with that, Your Honor. It is covered by intentional misconduct, and that's where Blackmore Partners is squarely on point. Where the lenders, where Stern and Maloney have engaged in a transaction where no transaction could have been worse for the company, that alone is enough to support an inference of intentional misconduct in violation of the duty of loyalty. And here we have much more.
Wait a second, I thought you just said you don't have a duty of loyalty. And then I go back to my statement to you, which is, if you waived your fiduciary duties and you didn't waive your fiduciary duties, then that clause means nothing. And that's the last thing we want to do, is say that that clause means nothing. But basically, everything you're arguing to me is that even though we waived our fiduciary duties, we didn't waive them. We didn't, and that makes no sense. So what is it that you think they actually
I can't just redo this. This is my argument.
I should clarify.
Mr.
Clarify, Your Honor,
Sinatra, we can hear you.
We do believe that the duty of loyalty survives to some extent. Aspects of the duty.
Well, what do you think you waived in that I'm waiving all my fiduciary duties? What do you think you waived?
We waived, for example, the corporate opportunity doctrine. We waived duty of
self-dealing isn't waived. That's exactly taking a corporate opportunity is self-dealing, right?
Your Honor, we're not saying that all self-dealing is actionable under Section 8.5. The corporate opportunity doctrine is not actionable. Intentional misconduct, however, is. In addition, the duty of care, where it's breached.
Well, how do you define intentional misconduct? I think that's the problem here, because even the excluded duty that you just referred to is intentional misconduct. If you take a corporate opportunity. All right. In any event, we'll give you time on rebuttal, Ms. Proctor. Let's hear from Mr. Sinatra. Go ahead, sir.
Now he's muted.
Mr. Sinatra, yeah, we kind of heard him fooling around with his tech people, and now we don't see him at all. Ms. Proctor, could you just text Mr. Sinatra and indicate we're waiting for him?
I will send him an email. I don't have his cell phone number.
Whatever you could do, send a carrier pigeon, that would do.
Yes, ma'am.
Well. Right, I'm willing to give this another minute, but if we otherwise don't reach Mr. Sinatra, then the best I can propose is that you can do rebuttal at the end of the calendar, you know, so that we can at least move our calendar along.
Yes, Your Honor.
Yeah. You know, I understand it's nobody's fault, but we have to deal with these technical issues in a virtual world.
Yes, ma'am.
I think this is him.
Hi. My apologies for
You don't
delaying.
have to apologize. We saw you having problems, but you have 2 minutes, Mr. Sinatra. Go ahead.
The last that I heard was the colloquy between Justice Scarpula and opposing counsel, which is right on point. That what happens in the face of this language and what the Delaware courts have made clear is that given the freedom that Delaware law allows parties to govern their relationship, they can make the determination that they will waive all common law fiduciary duties and replace them with any other duties they like as a matter of contract. That's what the Delaware courts have made clear. Our language, the language that's included in Section 8.5, is relevantly similar to the other cases that we have cited and shown to the court as being clear and unequivocal waivers of all fiduciary duties.
So let me just ask you a question, Mr. Sinatra, because your adversary really focused in on the exception of intentional misconduct, which, according to your analysis, would be a contractual duty. But what is it? What is intentional misconduct that would otherwise qualify under the contract to be actionable?
I want to be clear that intentional misconduct is not a breach of contract. Intentional misconduct is a specific tortious act undertaken maliciously with the intention and knowledge that it will harm the company. So when we talk about the reservation of fraud, intentional misconduct, and breach of law, we're talking about torts. We're talking about things that cannot be waived.
Counselor, this is Judge Singh. Is self-dealing intentional misconduct?
That is not intentional misconduct because the parties can provide contractually within their agreement whether or not there can be self-dealing. Delaware law would permit that. It could discuss the circumstances under which that would occur. Now, there was no self-dealing here, obviously, because there is no transaction between the sponsor and the company itself. There's the transaction that's alleged is a bribe, but the bribe that's being alleged is merely offering them employment and to pay them wages that they would have otherwise earned in that capacity.
But aren't they getting also an interest? Aren't they getting an interest as well?
They did not get an interest. Absolutely not. And
are they getting an interest in the future?
They are investing through Madison Capital. There's something that's in the record that indicates that a $90 million investment was made. There was no gift. Nothing has been given to them. And that is one of the things that's missing here. That's the key to the reason why there is no bribery. There is no allegation that
we're just dealing with allegations, so we're not going to get into who's ultimately going to prevail. But I think we understand your position on this, and now we're going to give final 2 minutes rebuttal to Ms. Proctor.
Thank you, Your Honor. I'd like to begin by addressing the UCC claim, which we again believe that Justice Sherwood properly upheld. And you've heard from Mr. Sinatra that there has been no gift given. Again, that allegation is not in the record, and that's why on a 3211 motion, Justice Sherwood's ruling was correct. I'd also like to address a point that Mr. Sinatra made in his opening, that it's entirely innocuous when there's a change of ownership to retain the construction manager. The cases in the record simply do not support this. They deal with management staying on after a merger. What we have here is a decision to retain an affiliate of the defaulting borrower post-foreclosure.
And Counselor, I'm sorry to interrupt you. Could you address that claim in the context of your cross-appeal with respect to your cause of action for a breach of the claim of good faith and fair dealing?
Yes, Your Honor. And this does go to the breach of good faith and fair dealing as well, because it shows that if there's nothing showing that this is a routine transaction, what we have here are specific concrete allegations of a bribe that were intended to interfere with the borrower's ability to exercise its absolute statutory right under the UCC to insist on an auction.
Well,
And
you
that
have a claim under the pledge agreement, I guess is what I'm trying to get at. Under the
Yes,
pledge,
sorry, Your Honor.
under the pledge agreement.
That that gives rise to a breach of the implied covenant of good faith and fair dealing under the pledge agreement, because the parties' agreement was to proceed in accordance with the UCC, and so the borrower is being deprived of the fruits of its bargain by this bribe, which of course is a violation of the duty of good faith under any standard. But the reason that this claim is unique and not merely duplicative is, first of all, it gives us access to consequential and punitive damages. And secondly, the standards of good faith are going to be different under the UCC as well, and under the pledge agreement. And that's why we think that claim should be reinstated. For the same reason, we believe that this court should reinstate our claim for conversion. The UCC is quite clear and explicit that it does not displace common law remedies. And Section 9(625) in fact expressly states that that tort liability can be pursued in conjunction with the UCC statutory claim. And then finally, on the breach of fiduciary duty.
All right, you're actually out of time, so finish
Yes,
up your sentence.
I just wanted to remind the court that we also have fiduciary duties owed in sponsor's capacity as a manager and in Stern and Maloney's capacities as remote controllers.
Okay, thank you.
Thank
Thank
you,
you
Your
both. Moore versus Nizam. You can proceed. Mr. Malesso? Jason Malesso? We have Ms. Friedman.
Yes, Your Honor, I am here.
All right, do you have a way to contact Mr. Malesso, who we seem to have lost?
Right, I am not sure. I can try emailing him.
All right, while you're doing that,
yes,
I'm going to take another case out of turn.
Okay.
Thank you.
You're welcome.
All right. Sabre Chemicals against Northeast Chemicals.
Michael for respondent, Your Honor.
Michael Cuso for defendant appellate Northeast Chemicals.
Mr. Cuso, you can proceed.
Okay. Your Honors, good afternoon. This is an appeal from two orders of the lower court, which sent this dispute, this lawsuit, to arbitration for the American Arbitration Association. The first appeal was from a denial of a motion to dismiss that had been converted into a motion for summary judgment. The court denied the motion and sent this case to the AAA. The second appeal is from a motion to re-argue that decision, and that motion was granted, but the court adhered to its decision to send this case to AAA arbitration. Northeast is of the view that this direction to send this case to arbitration was improperly and improvidently granted. Northeast contests the existence of an arbitration clause, but more significantly, it is Northeast's position that Sabre Chemicals, the plaintiff and respondent in this case, or on this appeal, waived any right it may have had to arbitration in the first place. In fact, every word and every act by Sabre below is inconsistent with its now claimed right to arbitration. It waived it by A, commencing this action in the first place. If there was an arbitration clause, why didn't it proceed directly to arbitration? B, it also waived it by not seeking arbitration at any time, especially after Northeast had moved to dismiss the action.
So it was actually in Northeast's alternate version of the contract where the arbitration clause first shows up, right?
Northeast, there were two paragraph 8s in this purchase order. The arbitration clause appears in
Now, my question is actually simpler than that. The first time that an arbitration clause kind of rears its head is when you make your motion to dismiss.
That is absolutely correct.
All right. And after you made your motion to dismiss, did Sabre ask for arbitration?
Not at all.
Did you ask for arbitration?
No, we did not.
All right. So the matter proceeds to a limited issue hearing before a referee, right?
Correct.
And that issue really was which one of the competing versions of the contract applied. You know,
Right
what's
again.
the one to
Right again, Your Honor.
Okay. The hearing's never held.
Pardon me?
The hearing is never held. The parties
Correct.
settled.
We entered into a stipulation.
Right. All right. And does that stipulation control this dispute?
I would think it does, and that's our position. Why wouldn't it? There's a provision in the CPLR that says.
I'm asking the questions.
Okay. Our position is it controls the dispute.
Okay.
Or the issue.
Mm-hmm. Any colleagues, any questions for Mr. Kozlow? Kuzo, I'm sorry. I seem to be mispronouncing everybody's name today. My apologies. All right. But I can get Mr. Grayson's name correct. That's easy. Mr. Grayson, can we hear from you?
Why, thank you, Your Honor. I appreciate it. Your Honor's going down the right path. The case was filed, and then almost immediately, the issue is which one of Northeast purchase orders controlled. They wanted the New Jersey one. We wanted the arbitration one. That was the sole issue of this case from the moment.
You didn't want the arbitration one. You wanted the New York one.
Well, we had a New York one.
You had a purchase order with a New York venue and law provision.
Sabre had a New York court provision in its terms and conditions.
That's why you started the action in New York, right?
Yes, Your Honor.
You didn't know about the arbitration provision, theoretically.
However, allow me, please. Judge James immediately said those terms and conditions don't apply because you never sent them to the other side. So immediately we are left with which one of Northeast terms are we? New Jersey, which is what they wanted, and the AAA, which is where we said we would go. And then
well, you did, but you said secondarily, we'll accept the arbitration now that they've put it forward. But really, Judge, we want this heard in the New York courts. Isn't that what you said?
Absolutely not, Your Honor. Once we were going to a JHO, there were only two options. It was either New Jersey under their purchase order, their fraudulent one, or AAA under their proper one. And that's why this whole case is what it is.
Why didn't you in your stip then say, we are going to stay this action and we will proceed with our claims in arbitration? Wouldn't that have been easier?
Well, it probably would have been easier, but the stip is prepared by them, and it said it's going to be. Allow me, Your Honor. It's going to be venued in New York where the AAA was.
Grayson, please.
Oh no, absolutely.
You didn't have to sign it, right?
Please. Yeah, but they never withdrew the summary judgment motion. They knew what was going on. They knew this case was going. This whole thing revolves around them not wanting to produce the emails.
Counsel, this is Judge Scarpula. If you thought that you wanted to go to arbitration, why did you commence a lawsuit? Why didn't you just start out by serving them with a demand for arbitration? You're the one who's got the document that says it, but you don't do that. You start a lawsuit. So when you start a lawsuit, even though you have an arbitration clause, that indicates to everybody involved that you're not going to rely on the arbitration clause. You started a lawsuit.
That's right. Up until our terms and conditions were thrown out. And if you read the cases on our brief, starting on page 33, starting a lawsuit and then going to arbitration, perfectly acceptable.
Let's assume that we agree with you that New York is the venue. Why not just litigate it in New York? That's what you chose to do to start with.
Because once arbitration was available, we had a date in October. This case should have been, all due respect, should have been over. We got an early date.
Counsel, this is Judge Scarpullo. Let me just say to you that it was available on day one. You had the agreement that you're relying on that said you're going to arbitration, but you chose to do something different.
We believed that on day one that our terms and conditions for New York courts applied. Judge James threw them out. Therefore, we said we'll take their real arbitration terms. And Your Honor, you were just involved in De Jesus last week, which says the court can search the record. So when they set up the stipulation and send it back to summary judgment, and they knew that they didn't file any papers, Judge James said, I searched the record. All I find is an arbitration.
I'm sorry. I'm just looking at the stipulation, and I just can't get over it. It's agreed between counsel that the venue of this action is to be New York County, and this action will be tried in New York County. Why do we need to go any further than that?
Because it says the venue is New York County, where the AAA is.
And this action
will
be tried in New York County.
Not what it says.
That's right.
Am I reading it wrong?
No, that's what it says. But where's the AAA? It's in New York County.
But the stipulation doesn't say the AAA. That's what Judge Singh is referring to.
No, but all it does, it withdraw. If you see, it says it withdraws the second branch of the motion to dismiss. That's the part that says, let's move it to New Jersey. So we're left with a.
No. Actually, it does. Actually, if I read the provision, it says that the claims, the waiving any claims that this action between the parties shall be heard in any other court or proceeding, meaning excluding a proceeding, and I read that as excluding arbitration, other than the Supreme Court of the state of New York. That's court. Those are courts. That's not arbitration.
Excuse me, Your Honor, I didn't hear you.
Those are courts, not arbitration.
Yeah, and the court had a summary judgment motion pending with an arbitration clause. All they did is they looked
put in a notice for arbitration, a demand for arbitration. Then you didn't have to wait for a stipulation. I don't understand.
Your Honor, you have to remember that from the moment they filed their motion to dismiss and the judge sent it to the JHO, there were only two possible choices, and we were happy to take the arbitration because we could prove the arbitration cost. We spent a year.
You know what? I read the affidavits, but the affidavits of your parties only said, we'll take it as a second choice. We want to be heard in New York County. That's what you said.
That's because we knew that
you know what? We will look again at the record and see if my understanding is correct or we're missing something based upon what you said. All right, we're going to hear from your adversary on brief rebuttal.
My only point is, remaining point is that if you look at their papers below, they argued against arbitration. They urged they argued in bold print on many occasions that arbitration wasn't applicable and that this case should be tried in New York County. I have nothing further to say, and I rest on my papers. Thank you very much.
Thank you both.
Thank you.
All right, let's go back to Moore versus Nizam. I think Mr. Malesso, you're with us now.
I believe so, Your Honor. Thank you. I apologize.
Yeah, that's all right. I think I was the one who let you back in. So.
May it please the court. Thank you, Your Honor. So before I get to the issues of the bond and the bill of particulars in this case, I just want to point out or clarify one issue, is that the case partially was dismissed for failing to give discovery, and neither of those issues are discovery. Neither the bond or the bill of particulars are discovery issues. There's no evidence that was ever withheld. I mean, there was no prejudice to any party ever articulated by whatever failures they allege that we committed in this case. So the bond.
But failure to post a bond can be remedied by a dismissal, right? I mean, that's true. I understand it's not discovery, but it is. It was an extant order that was not complied with by somebody who was an out-of-state person suing. And one of the remedies for failure, it's not an automatic remedy, but one of the remedies for that is dismissal, correct?
That is absolutely correct, Your Honor.
Okay.
And I mean, the only thing I could say in response to that is that is a provision that was made however long ago to apply to particular cases that I think are completely inapplicable in a modern medical malpractice setting, where there are many, many other ways to deal with whether or not a case is legitimate or frivolous, which is what the whole bond point was addressed to. And we didn't even get that.
Counselor, I'm not following your argument. The issue here is whether or not you complied with various court orders. Plain and simple. And
that's correct.
If you didn't comply, was it willful?
It was not willful in the sense that there was no harm to anyone.
But that's not the standard. It's just, so in other words, I can ignore an order and not comply and say, well, there was no harm, and therefore I don't have to comply and it's not willful. That doesn't make any sense to me.
There's an order that mandates that when there's a law that mandates that when a party requests a bond, it has to be granted. And it was. But
I guess I'm looking at it from a broader picture. There's with respect to your BP, there was not compliance. So broader picture, why didn't you comply with the court's orders? Whether it's with respect to providing a specific bill of particulars or providing a bond.
Well, I believe we did comply with the court's orders concerning the bills of particulars. I think
that's after the horse left the barn, right?
No, I don't think so. I think we actually did before it was dismissed. And again,
Judge Scarpula, when you supplemented by objecting. You didn't particularize any of your allegations against the doctor who sought by 6 orders for you to particularize your allegations against him. All you did was object, which is not responding, and you had never objected to that in the 6 previous orders that you didn't comply with, correct?
That's correct, Your Honor, but I believe
that's not complying at all. That's objecting 6 orders later. That's a completely different thing.
But if it was,
I'll let you answer the question, and then your time is expired, though.
I believe that the bill of particulars were initially sufficient to put them on fair notice that there was no need to supplement it any further.
I see. So then why not just appeal as opposed to just ignoring court's orders? So sorry, it's a rhetorical question, counsel.
And you signed them as stips, so you couldn't appeal. All right. You agreed. All right, let's hear from Ms. Friedman. Ms. Friedman? Go ahead.
Good afternoon. Yes, thank you, Your Honor. Good afternoon. May it please the court. My name is Elizabeth Friedman. I am appearing for the municipal defendants, respondents, Dr. Mark Ingram and Health and Hospitals. Your Honor, the Supreme Court properly dismissed this action as against those defendants after the plaintiff failed to provide an individualized bill of particulars as to Dr. Ingram and failed for 9 years to post a bond for security for costs as required by statute.
There was a stay in place for a good part of that. So I don't know that time is chargeable against them, but Your Honor, we'll leave that aside. The orders took place and they were outside the stay period, and they were consented to orders, were they not?
Yes, Your Honor. And in fact,
the orders were question, just so that I'm clear that I understand this. The doctor and the facility were both sued, but the plaintiff, every time that the plaintiff went to the facility, the treatment was not necessarily by the name doctor. Is that true?
Well, Your Honor, basically the plaintiff, it was by, are you talking about went to the Health and Hospitals facility? Is that
right, that's what I mean.
Mentioning? Well, it's right. It was a number of different doctors, but a number of different doctors were involved in this, in the decedent's care, and a number of different institutions were also involved in the decedent's care.
Leaving the institutions apart, I'm just trying to deal with the idea that you really did need a bill of particular that separated the doctor from the New York Health and Hospitals institution to figure out where the liability was being claimed.
That's absolutely correct, Your Honor. So in fact, even if the claims against Health and Hospitals are limited to claims of vicarious liability, Health and Hospitals would still need to know which claims were being asserted against Dr. Ingram and what claims formed the basis for vicarious liability. the purpose of the Bill of Particulars is to narrow the claims and to specify for purposes of preparing a defense. The municipal defendants could not prepare an adequate defense here based upon the laundry list of allegations and injuries that were asserted in the 3 different Bill of Particulars, which were virtually identical, as the court found. And even the supplemental Bill of Particulars did not adequately narrow the issues. That supplemental Bill of Particulars was almost the same. And in fact, it only alleged 7 fewer injuries than the huge list in the other Bill of Particulars. So, and in fact, as this court has pointed out, the plaintiff failed to comply with 6 different orders. They were all issued as to the Bill of Particulars after the bankruptcy stay was lifted. And even as to the bond, the bankruptcy petition was filed 5 months after the plaintiff failed to post the bond for security. So, yes, thank you. We ask that the order be affirmed.
I know I'm cutting everybody off in the middle of a sentence, but we're just trying to move it along with
Absolutely. Thank you, Your Honor.
No disrespect to anybody today. All right, Mr. Molesso, go ahead. You have rebuttal.
Your Honor, the only thing I'd say is that the Bill of Particulars is that if it is a vicarious liability argument and he was an employee of the hospital, I don't see why the claims would be any different.
Okay. Anything, any questions, colleagues? No. All right, thank you both.
Thank you.
Carlin versus Pierce.
Yes, Your Honor.
Okay.
May it please the court, Your Honor. My name is Steve Comer, and I represent the appellant in this matter. Good afternoon, all. Your Honor, obviously, and I will concede that over the passage of time since this custody order was issued by the lower court, times they have changed, and I'm making a very general statement, which means that the relocation issue, which was raised on this appeal, could very well have been stale, or at least is very well stale at this point in light of the fact that the child has been living in the state of New York since this custody order was issued for approximately 3 years.
Can I ask a question?
Yes, Your Honor.
Yes. So at the end of the custody decision, the judge said that your client could have 6 supervised visitations and we would monitor what was going on. And then she could ask for different and more robust access. Did that ever happen?
It did, Your Honor. We did make an attempt prior to the pandemic coming down to go into the court, not before this lower court, but before the family court, and try to modify the custody so as to provide my client
with the family court?
Yes, with
Why
additional.
Why did you do that? It looked like the Judge Cooper kept continuing jurisdiction.
Well, unfortunately, I gave my client the option of doing that, Your Honor. Unfortunately, she had.
Who gave you the option?
I'm sorry.
Where was the option? I'm sorry.
The option is the family court had concurrent jurisdiction, Your Honor.
I know all about jurisdiction.
I know, Judge.
But the court was exercising ongoing jurisdiction on this, really? You went to the family court?
That seems to be the issue, Judge, is whether or not the court did have ongoing jurisdiction, because that is not contained within the judgment of divorce, nor is it contained within the parenting or the custody order of the lower court. So essentially, my client is left with what I would term to be a very, very restrictive access schedule. With really,
it may have changed already. It could have changed 100 times over by the passage of time.
It could very well have, Your Honor. It could very well have. But my concern here is that my client, although the lower court did provide her an opportunity to go in and readdress this issue, and I should point out that she did in fact complete those 6 supervised visitations. That my client no longer had money to pay the existing law guardian on the case, and that she needed to go to family court so that she could get at least counsel in terms of an attorney for the child.
So now we are limited in terms of our review, because she appealed. She apparently had money to appeal. That we are left with a record that was developed in terms of what the visitation and access needs were at the time the decision was rendered.
Correct.
Right?
And although we did try to remedy, I'm sorry, Your Honor. Did I cut you off?
I want to know that we see it the same way.
Okay. We do see it the same way, Judge, but unfortunately, it's not contained within the custody order. It's not contained within the judgment of divorce in terms of my client's right to go back to petition the court, or at least request the court, to amplify or enhance or liberalize the access schedule that she has. As we stand right now, or at least as we've stood for the last 3 years, is that the respondent, based upon a reading of the custody order, basically, for lack of a better characterization, holds all of the cards with respect to an access schedule. And I am referring specifically to that portion of the custody order, which states that the parties, or at least the appellant in this matter, may have any other such visitation as agreed upon the parties. And that's a provision, which I don't think I sufficiently addressed in my brief. And if the court would permit to just, and I know I don't want to go over time, but just to address that, it seems to me that the restrictive, I would term it as a very restrictive access schedule, was prompted by concerns that the lower court had regarding the appellant in this matter. But that's not the way the custody order reads. By the court giving the parties the opportunity to agree upon any access schedule that they might otherwise agree upon, it sort of removed that element of any concern regarding the child. We would not have to go back to the court to request the court's permission for a liberalized access schedule. Rather, that would just be an issue that the parties could resolve or try to work out between themselves. And I certainly don't want to say anything which dehor the record, but those visitations, for whatever reason, have not taken place. And I will not discuss any of the history post the issuance of this order. But at this point, it's our position that the order itself was way too restrictive based upon the circumstances at trial. And notwithstanding the fact that the lower court found some significant concerns with my client, I think that was alleviated by the forensic examination, Dr. Cohen.
By the way, I just want to be clear also, when the court made its determination about the custody and access, it still was exercising jurisdiction over the divorce action, right? That hadn't been concluded.
Well, the divorce had been concluded, Your Honor, because remember, there were 2 separate orders issued. There was an order of custody and parenting time, or an access schedule, which was issued separate and apart from the judgment of divorce, which primarily dealt with the financial issues. And those were never really an issue below. This case was litigated primarily with
the custody decision, when it was made and when the court said, let's see how the next visits go, the court, you said, didn't reserve continuing jurisdiction, but in fact it had it by operation of law because there never was a judgment at that time.
At that time, there wasn't. Until there was a judgment, yes. And then a judgment was rendered.
Right, we agree.
We agree, Judge. Absolutely. Yeah. I will not make a disingenuous statement about that. And while our remedies may, in fact, may exist with the lower court, obviously the passage of time may change things, but I do agree with Your Honor in that sense. As long as there's clarity there that I can still, after the judgment of divorce, bring an application before the lower court, if it is appropriate, and I stress if it is appropriate, to try to liberalize the access schedule.
If you're not getting agreement and you think that's wrong.
Correct.
Right.
That's correct, Your Honor. And that being said, again, Your Honor, I would just like to re-stress, and then I will finish up. I know I've exceeded my time, and I apologize.
You have, but, it's an important matter concerning children. We're not.
Thank you, Your Honor. Again, I think without dealing with any of the other issues here, I think that we have an order here that says the parties can agree on any access schedule that they agree upon. I don't think we'll get consent from the respondent, although I can't say one way or the other whether he would consent today. But it puts my client in a predicament where she would have to go back to court to request additional access. Right. And that being said, Your Honor, I'm going to rest on my brief, and I appreciate the court's time today.
Thank you.
Thank you.
All right, Mr. Secular.
Yes, Your Honor, may it please the court. My name is Evan Secular. I represent the respondent father. I do believe the procedural history as to what occurred in terms of the mother's access is particularly important here. As soon as Justice Cooper signed the judgment of divorce, the mother made an application in New York Family Court seeking parental access with the child. That matter was consolidated by an order to show cause that I filed on behalf of my client, and the matter returned to Justice Cooper. Ultimately, the mother opted not to pursue that order to show cause, and it was dropped. Since December of 2019, the mother has not had a single visit with the child because she has not come to New York. She has not.
I'm gonna stop you there, because just as I said to Mr. Kumar, on some level, this history is not before us. So it shouldn't taint us one way or the other. If the parties can't agree on access, then there's got to be a reckoning of this in court, right?
Your Honor, respectfully, there's no issue of agreement because the mother has not come to New York.
It doesn't
She
matter
has not flown
why.
here.
It doesn't matter why. Right? There's no agreement.
I mean, but
right?
I would agree
You know,
there's
right
no
now,
agreement.
you
My
could
client doesn't
waste your breath and start to tell me everything that's happened since 2 years ago. But there is a remedy here for either side, right?
I would agree with that.
But it's not up in the appellate court.
The lower court and make an application or request time of my client. There's been no request for time.
Okay. All right. Anything further,
Your Honor,
Mr.
I just
Secular?
would like to. No, I just do think that the fundamental nature of the appeal had to do with the request for relocation and the issues of fact that were pending before it, as well as a claim of judicial bias that the court, that I believe the court considered the proper interest of justice and made its determination. These were issues of fact and the best interest standard under Tropea and Eschbach that the court considered when issuing its decision.
Okay, thank you. Let's hear from the attorney for the child.
Thank you. May it please the court. My name is Stephen Forbes. I represent the child in this matter. I do believe that the court is correct when it says that a lot of the issues that are currently before it have been become stale as a result of the passage of time. A lot of things, whether we talk about them or not, obviously have happened in this child's life since the last time they were in court. And while the appellant is complaining generally about her very restrictive access schedule and whatever happened afterwards, the reality is simply that there was a reason for that restrictive order, and there was really
at the time it was made, and that's what we need to look at.
At the time it was made, we can't really talk about whether or not it's currently appropriate or not. But
correct, because families change over time; they're dynamic.
So the fact that there was a remedy available to the appellant then, even rather than even appealing, was to finish the course of visitation that the court had ordered, and then seek to modify it and broaden her access, and that is a remedy that she did not seek. Instead, she came to this court seeking to basically set aside.
Well, one thing is not preclusive of the other.
No, I understand that, but unfortunately, it is to the extent that because we are now in a very different time period, that those issues that were presently before the court then make this court's decision today much more difficult. So unless the court has any other questions of me, I would rest on my papers.
Any questions?
No.
All right, Mr. Komar, rebuttal?
Yes, just 1 minute, Your Honor, less than that, actually. I just would like to go back again and reiterate the point that I had made previously, which is what was the reason for issuing such a restrictive schedule? And I think that everybody walked out of court thinking that a restrictive schedule by the lower court was issued in light of the fact that there were concerns for the child. But the fact that the order specifically states that the parties are free to agree on any access schedule that they decide, alleviates or at least removes any of those concerns or flies in the face of those concerns. Obviously, if the court had lower court had such significant concerns about the child's welfare and emotional well-being, that it would not have put that provision in to the judgment. That being said, Judge, I will rest on my
I'm not so sure. I think it's a fairly typical provision, but that's neither.
I won't disagree with that.
It's neither here nor there. I understand your argument. Yeah.
Thank you,
All
Judge.
right. Any questions, colleagues?
No.
All right. Thank you all.
Thank you, Your Honor. Thank you.
Thank you.
Yeah. Advanced Aerofoil versus Mission Point Capital.
Yes, Your Honor. Good afternoon, and may it please the court. My name is Eric Latzer, counsel for the appellant, whom I'll refer to as AAT. This case, Your Honors, is about a Supreme Court justice who, after 6 years of litigation, dismissed AAT's entire case without citing to any law and without applying.
Counsel, let me stop you there. This is Judge Singh. Did the complaint or any of your interrogatory responses attribute to TurboCare was there any reference damages to TurboCare, lost profits, that the LTA with TurboCare had been terminated, anything like that?
Your Honor, the complaint generally alleged damages. That was our only obligation.
Sir, I was a little more specific than generally alleging damages with respect to TurboCare. If I did a search of TurboCare in the complaint, would it pop up?
No, Your Honor. However, we.
I'm sorry. Go ahead.
I was just going to address Your Honor's point as to the interrogatories. So the first interrogatory asked us to identify people with knowledge of the case.
Okay. Now, when was this action commenced?
This was commenced in January 2014. There was a motion to dismiss originally filed. It was granted in part. It was affirmed by this court.
So when was the first time there was a reference to TurboCare in this case?
Your Honor, in July 2016, there was an email sent from counsel to counsel identifying the TurboCare CEO, Mr. Sigmund, as a person with knowledge and explaining in great detail the topics to which he would testify. That's at page 1286 of the record, Your Honor. So that was in July 2016. That was in the early stage of this case. Now, around the same time, documents were produced. Within those documents was a copy of the relevant agreement, the long-term agreement with TurboCare. And Your Honor, there were also depositions ongoing in 2016. TurboCare was referenced numerous times at those depositions. And Your Honor, counsel for Mission Point, prior counsel for Mission Point, was present for every single one of those depositions, of course. He asked questions at those depositions. He asked us to produce a witness concerning damages, essentially a 30B6 witness as it pertains to damages. We produced that witness, and he did not ask him a single fundamental question, such as, what are your damages?
So
tell me how you calculate
it. When you say in 2016 there were depositions, which one of your witnesses said that the company lost this amount of money from the loss of this contract? Which one of your witnesses said that?
Your Honor, several witnesses testified as to the loss of the contract. With respect to the amount, however, Your Honor, that was
connecting the two. That's what I'm asking. What deposition testimony do you say in 2016 connected? Because frankly, your claim is that, they breached the non-disclosure agreement by poaching us. So normally damages, what you're seeking now, which you didn't seek in the arbitration or anything else, is not a normal consequence of that type of claim. So again, my question to you is, in 2016, all these depositions that you're saying, who connected the loss of the contract with the loss of with the poaching?
Your Honor, Mr. Wolf and Mr. Ritchie were two witnesses who testified. They both testified as to the loss of the contract. But to Your Honor's question, though,
I'm asking you about the connection. I'm asking. You're saying this was my damages, and you knew about it in 2016 through the depositions. I'm asking you, where in the depositions did those witnesses say, those fact witnesses say, we lost this entire contract due to your poaching our people?
Mr. Ritchie and Mr. Wolf both testified as to the loss. Your Honor, if your question is who exactly said these
even generally, I read those depositions and I don't see either one of them saying that is a connect. That's what our damages are. That's what we lost. No one said that in 2016. There may have been the fact of, after they left, this contract left, but you are saying that those depositions put your adversary on notice. And I'm asking you, if you have deposition pages, let me know, because I didn't see it.
Your Honor, I only have the deposition pages that are cited to in our brief. But again, Mission Point's counsel, their prior counsel, was at that deposition. He called for a witness with respect to damages. If he had any confusion He should have asked the question. A party cannot be permitted to bury its head in the sand for 5 years of litigation, retain new counsel, and have that new counsel
But counsel, you, based on your argument, it's not till 2016 that you say there was notice, and then on top of that, you wait till 2018 to explicitly raise the theory. Why the delay?
Your Honor, the case discovery hadn't begun until this court affirmed the dismissal order. So discovery didn't start until.
You don't know what your damages are at the beginning. You don't know what the basis of your you don't need discovery to know what
Your Honor,
of your damages are. If your theory is from day one that our damages were the value of this contract, why not just plead it either in your complaint or in your bill of particulars, or have your witnesses explicitly testify to it? Why not do any of that?
Your Honor, there was no bill of particulars served on us. Another example of how. Okay, so the initial discovery response referred to expert testimony that would be presented on damages. Now, to the extent the court thinks that interrogatory response or even the deposition testimony were not sufficient, the remedy in this case should not have been dismissal of our entire case. The court had an obligation to apply the discovery sanction statute, CPLR 3126. It did not apply it. It ignored it entirely. Under CPLR 3126, this court has repeatedly held.
But why? I don't understand. Why is this a discovery sanction? The issue is notice of your damages. So isn't the standard really, did the court abuse its discretion in dismissing this claim? Isn't that the issue?
No, Your Honor, it's absolutely a discovery question. It's a failure to disclose our damages theory in discovery. And CPLR 3126 expressly.
It's a failure to give notice as to what your damages are, loss of this contract. It's really basic, isn't it?
Your Honor, whether it's referred to as a failure to disclose or a failure to give notice, it absolutely falls within 3126. That 3126 addresses a failure to disclose in discovery. And the only way that dismissal can be ordered as a sanction is if the side alleging a discovery impropriety makes a clear and conclusive showing that the other side, here AAT, acted willfully, contumaciously, or in bad faith. There was no showing. And in fact, Your Honors, when Mission Point filed its first motion to strike, it didn't even argue it. And its secondary argument in that motion was reopen fact discovery. And that's exactly what the court should have and could have done. The note of issue hadn't been filed. Instead, it ordered this completely draconian result, which was to dismiss our entire damages claim, to deprive us of our day in court, all based on 2 interrogatory responses, which were served back in February 2016. And again, they never objected.
Let me just interrupt you. The remedy was not. The remedy was the court struck your expert's report, right? That's what the first order was.
It was more than that, Your Honor.
Expert report because you never disclosed it in a 3101D, and then it was stricken, right?
No, Your Honor. If you turn to page A58 of the record, the order issued on the motion to strike struck more than just our expert. It struck the damages.
Right. Without that expert report, you couldn't prove damages, right?
But it still precluded us from even mentioning the loss of the TurboCare contract because that was the theory.
How could you prove that damages? How could you prove those damages without that expert report?
Your Honor, it still was more expansive. We did need the expert report, but this wasn't a 3101 motion, Your Honor. There was no law applied at all. That standard wasn't applied.
Mr. Latzer, you'll have some time on rebuttal. You've far exceeded your time. All right, let's hear from Mr. Weiss.
Good afternoon, Your Honors. May it please the court, Jordan Weiss from Goodwin Proctor representing respondent defendant Mission Point Capital. Before I begin, I just want to apologize for not being on the video. I intended to be, but the technology didn't comply.
Don't worry about it. I can hear your voice. Right, we make allowances for the technology. We've been doing it all day. All right?
Thank you, Your Honor.
So tell us, what was this motion? What was the motion for? And what did the court decide? There seems to be confusion.
Well, Your Honor, we moved to, I'll give you a little procedural history. When we got the expert report right after that, there was a status conference. At that time, we alerted the court that we may have to make a motion to preclude or strike.
The expert report,
we then
3101T motion.
We then took some expert testimony that we took the depositions to determine whether we did in fact have to move. And afterwards, we had another conference with the court. At the conference, Justice Cohen suggested, isn't this really a motion in limine? That there haven't been evidence to put this in front of the jury. Shouldn't we just wait till trial and make it a motion in limine? Which was in fact the effective nature of our motion, relying on the inherent authority of the court to prevent a party to come to trial with a theory that they have no support for, that they haven't provided notice of in the complaint or in discovery. We explained to Justice Cohen, and I apologize for my voice, I don't know why it's fallen out. We explained to Justice Cohen that we could do that, but as a practical matter, it gave a lot of power to AAT. If we were facing down the barrel of a trial where there was a $70 million theory that we knew nothing about, had taken no depositions on, had issued no subpoenas about, received no document discovery on, that would be prejudicial.
Scarpula, how do you respond to counsel's argument that in the 2016 depositions, the witnesses testified that this was their damages, that they lost these contracts because of your client's poaching?
Yeah, so thank you for that question. First and foremost, much of what my opponent said was factually untrue. So he said, for example, that there was no discovery at the time of that email. That's absolutely false. Not only had they produced hundreds of pages of discovery, but all 4 depositions took place before the first department upheld Branston's dismissal. The first time that email was sent was after the dismissal was affirmed. And the story here is obvious. If you look at the timeline, it is obvious what happened here. TurboCare was supposed to have been terminated in 2012. They brought this case in 2014, meaning in 2014, they knew that a $100 million client supposedly terminated as a result of our alleged bad actions, and it's not in the complaint. It doesn't enter into the litigation in any form or fashion until like a week after the affirmation of the dismissal of the largest part of their case. It was invented at that time. And it began with the sending of a single email, which in retrospect was obviously very important, but at the time was utterly meaningless to my colleague, Mr. Shanahan, because at the time we knew TurboCare had nothing to do with this case. And how did we know that? Because they didn't mention it in response to our interrogatories on their damages, because they didn't identify a single TurboCare employee in response to our request that they identify all witnesses who might have knowledge of the case. And I actually think that last one is the most galling and troubling, because ultimately they tried to make the CEO of TurboCare their expert/fact witness. So when they declined to identify him or any other TurboCare employee, they outright either were deceiving us, which I don't actually believe is true, or didn't know to include them because they hadn't invented this theory yet. The problem is by the time they actually did, and they served in 2018 their expert report, it was 4.5 years after the case had started. It was 3 years after the motion to dismiss was granted. It was 2 years after we had deposed all of their witnesses, and it was 3 months after our summary judgment motion was denied. As a result, we were essentially robbed of the chance to conduct any discovery on the critical issue of this case. Now, my opponent suggests that this is a 3126 issue, and therefore Justice Cohen's decision is error because he didn't find willfulness or bad faith. Well, as a starting point, we disagree. We did not seek discovery sanctions, nor did we obtain discovery sanctions. The panel has 2 sets of case law in front of them, those cited by the appellants and those cited by Mission Point, the respondent. They are very different lines of cases. The cases Mission Point cites show that the courts have the inherent authority to prevent a party from proceeding after discovery to change their legal theory and then proceed to trial. None of those cases involve 3126. Alternatively, the cases cited by our opponent all concern a very different fact pattern. The party had a continuous, consistent theory, but refused to produce discovery regarding that theory. That is not the circumstance the facts of this case.
Okay. All right, any questions, colleagues? All right, let's hear from Mr. Latzer on rebuttal, please.
Thank you, Your Honor. So, Your Honor, this argument, the appeal here is predicated on their claim that they had no notice of our damage, of our damage claim. 2 points in this regard. First, I think it's important to point out that this is not a case where we're alleged to have changed a damages theory and asserted a new one different from the one that we had originally identified. This is a case where they're claiming they had no notice whatsoever about our damages claim for 5 years of litigation. And Your Honor,
What's the distinction between that?
Because
I don't really understand. No notice about your damages theory, and it was a new theory. Is there really a difference?
Yes, Your Honor, there is a difference.
What's the difference?
Well, one of the differences is that this goes to the onus on them to ask a question. Say to us, hey, you were silent as to your damages. What are those damages? This isn't a case again.
Give you an interrogatory during the main robust part of discovery that said, tell us all your information on how you calculate damages, and it was radio silence on this theory. Am I wrong?
No, Your Honor, because we did the initial response, but then we supplemented and amended by email. And
Wait a second. What did you say in your initial response?
We said that we would produce documents, which we did. We said that we'd have witness testimony, which we provided, and we said that we'd have an expert report, which was produced. And then we followed up.
That's not a response of that is somewhere down the line we will figure it out, and when we do, we'll let you know. That's not a discovery response. The discovery response, if you had said it at that time, was we lost this contract. Why didn't you say that?
Your Honor, again, to the extent the court thinks that the interrogatory response was not sufficient, the remedy here could not be dismissal because 3126 governs that interrogatory response and the sufficiency
what
of
you are saying is you gave what I'm saying to you is your response didn't give any notice of anything. You're saying you gave notice, but you didn't because that response gave notice of nothing.
Your Honor, the onus was on them to ask a question, do something. This is a party that buried its head in the sand. Discovery is a two-way street. And again, that's where I go back to the fact that we didn't change up our damages. To the extent that there was confusion from our first interrogatory response, they needed to just ask a very simple question. And Your Honor, this position that they have that they had no idea what was going on here. And again, this is we've never heard from prior counsel, Mr. Sheehan, about this. We've asked for an affirmation from him repeatedly. He's never said it. And that's because he well knew what the damages were about. Because there are so many questions that have gone unanswered for Mission Point. What were they litigating about if they had no idea what the damages were? How could they assess liability?
I don't understand why he would give you an affidavit, but all right. All right, I think we understand your position.
Ask one last question. What did you claim your damages were in the arbitration?
Your Honor, I was not part of that arbitration. As I understand, it's completely different than anything that's before this court.
I'm just asking, did you claim those? Well, the arbitration was not completely different, but did you claim those damages in the arbitration?
I'm not sure, Your Honor. I was not counsel involved in that.
Okay, thank you.
Thank you.
Okay, thank you. Thank you both.
Thank you.
The next case is Harris. Let's hear from Mr. Mobarga.
Mobarga, yes, Your Honor.
Yes, I know I'm mispronouncing everybody's name today. My apologies.
I'm counsel for Bernice Harris and Allison Harris Shafini appellants. May it please the court, Your Honors, good afternoon. This is a very straightforward case after all the smoke is cleared. It is about an LLC.
It didn't seem that straightforward, but go ahead.
Fair enough. It is about an LLC agreement and its plain terms and whether the transfer to a third party violates those terms. That is it. The lower court below made 3 errors in denying summary judgment. That Bernice, Stephen's wife of 56 years, including upon his death, should receive his 19.35% interest upon his death as the LLC operating agreement requires. First, it failed to recognize—
let me stop you just there, because I have to say, in terms of couching your arguments, I don't think that you could really couch it in terms of equities on one side or the other. I think we're talking about legal interpretation of the LLC and the effect of the operative documents here. So I think that that's really fair argument. You know, I don't think we need to know if this was a good marriage, bad marriage, if he had a better relationship with Betsy or not. It's not the issue, right? You'd agree with that.
I'm happy to stick to the legal issues, frankly. I think.
Okay, good. Me too.
I just said that the lower court failed to recognize as a matter of law the validity of the LLC operating agreement. It was signed and initialed by all members. It contained all material terms. And all parties reviewed the original, not on one, but 2 occasions before filing their summary judgment motions. The purpose of these viewings, these 2 viewings, was to confirm that the provisions were exactly the same as those in the papers filed by the parties. And all the parties did confirm that. Second, the second mistake that was made below was the lower court failed to recognize or cite the restriction on assignability in the operating agreement, which restricts assignments only to family members. So leaving aside the equities, but a one-time girlfriend of the decedent, when the decedent is still married, is not family.
Counselor, that's sort of unfair characterization. Okay, so stay away from that, or we can go into it.
No.
It's more than that. So stop that.
I'm saying that is just. I meant that there's a girlfriend, for however long it may be, is it's not family.
And I think the reference was a loving partner. Well, that was his reference. So
Well, right.
Yeah. So come on.
Fair enough. But the respondents don't even argue that it was family in any of the papers in the lower motion or in the lower court. And finally, Your Honor, the lower court mistakenly applied the law on wills in interpreting the operating agreement, which is a business agreement involving multiple members. The Court of Appeals in Hillowitz specifically held that transfers upon death in operating agreements agreed to by all the members are not testamentary dispositions. They do not so they don't have to comply with the law.
But they're enforceable, right?
Yeah, absolutely they're enforceable.
Right.
Yeah. But they don't have to include the hyper-technical language that goes along with wills. So if members got together in an operating agreement and said, upon my death, my interest shall go to X or Y, they don't have that operating agreement is operable. It's enforceable.
So, Counselor, going back to the issue of family members, clearly Tamara is a family member, right?
I actually, and this is not to besmirch her or anything. That actually hasn't been proven yet. But let's just
okay. Let's assume for argument's sake, or argument for the purpose of my question. So why can't we skip over and go to Tamara's remainder interest?
Well, that's a very specific trust and estate issue, because the actual transfer to Betsy, if it's invalid as a life estate, then the question becomes for the court is, can you accelerate that other interest? Let
me ask you a question. Even if we assume that you can't, because it was contingent upon the life of Betsy, right? That's how she dates. It doesn't defease, though, right?
It's not indefeasibly vested because it's not certain. The only question is at the time.
I understand, but the disposition, it doesn't fail because the life estate fails, does it? It's just you wait for the contingency.
Well, the question is once the life estate fails, the question becomes, should we accelerate the remainder interest?
But I don't know that you have to accelerate. That's what I'm asking you.
Well,
I know that's your position, and I'm willing to consider the idea. All right, let's not accelerate it because it's contingent. It's contingent on the life of Betsy, and we don't know. Or it's contingent on Tamara outliving Betsy, right? That's the contingency before it vests.
Yes, and there's other.
But does the remainder defease because the life estate is no good?
No, the remainder defeases because it's uncertain. So the remainder defeases because it's uncertain. It's not. So once you get the life estate out of the way, you just focus on the remainder interest.
Correct.
And because there's 3 other people that might get it. So when there's that much uncertainty, you can't accelerate it. That's like black letter law.
No, but I'm saying leave the acceleration piece aside.
But unfortunately you can't.
Can you? What? well, I don't know, unfortunately or fortunately, I'm asking as a matter of law, can we just wait it out until the contingency occurs and then tomorrow would take, or not?
No, it's always at the
Why?
time of the interest. That's what the law is because you cannot give it to somebody else to use if the possibility is that it may go to somebody else due to another contingent event. So you can't give it to tomorrow and then wait and see what happens with Betsy.
No, you couldn't give it to tomorrow.
You couldn't.
You could not until until the end of Betsy's life, assuming tomorrow is still alive.
Right, but I'm saying if the life estate is invalid, which it is in this instance, you cannot give it to the remainder, with any of the remainder men, frankly, which
at
is
that time.
No, yeah, at the time that it was created, it fails to give it to any of the remainder men, which is basically 3 people that possibly could get it. So because of those 3 people that possibly could get it, the entire acceleration fails because the law at the time of the drafting of the interest is not certain who it goes to, so that acceleration fails, and that's estate powers and trust in state law. It's black letter law, and that's the way it is because we don't know who it's going to go to.
Okay. All right. Let's hear from the Lichtenstein defendants.
Yes. Good afternoon, Your Honor. Daniel Murphy here. So I represent Andrew Lichtenstein in this lawsuit, and our position is pretty simple. My client's a nominal defendant, and as a nominal defendant, my client has a 50% interest in the company at stake here, TJ Montana Enterprises.
Right.
And
Counsel,
the issue.
Counsel, how is your client aggrieved by the court's decision? How did his impact? He has 50% interest, right? So how his interest is not affected, correct?
Right. This is actually precisely our point, is that he's not aggrieved by this decision at all. He's been brought into this lawsuit for the sole purpose of clarifying many of the issues that there's confusion about in this lawsuit. And that's precisely our point, is that he doesn't stand to gain or lose anything, regardless of who this 19.35% interest actually transfers to. His 50% interest will remain unaffected. And because of that, that actually qualifies him under the dead man statute.
Let me stop you there for a second. How about with respect to governance of this company? He's being forced to take on Betsy.
Right. Well, again, what we're looking at right now is his 50% interest. Regardless of who this 19.35% interest passes to, he's still going to own 50% of the company at the end of this.
Won't it affect the governance? And isn't that a basis to say that he was aggrieved?
Well, it wouldn't aggrieve him personally. I don't think that might be an issue for TJ Montana. But as far as my client personally, he has an interest in this company. And regardless of the outcome of this lawsuit, that interest will remain the same no matter what. And that's really our position for why he's not an aggrieved party here in this lawsuit.
Wasn't the whole purpose of the dispositional restrictions on the other 50% shareholders' interest was so that your client each of the 50% shareholders could decide who they were going to be partners with?
Yes, I believe that's what it was. However, I think the issue here in this lawsuit is that now there is multiple versions of events where we have multiple parties claiming that one of the other managing partners had transferred an interest to them. And now we have multiple different versions of events here. And so again, as a nominal defendant, our role of being brought into this lawsuit is to clarify that because my client is not aggrieved, his interest remains unaffected in this company, regardless of who wins.
This is Judge Scarpula. Your client doesn't hold his interest individually, correct? He holds it via an entity.
He holds it through TJ Montana Enterprises, but as far as the portion that is controlled by him.
The TJ, so that's what you're saying is TJ Montana would be affected by who its LLC members is, but not your client individually, because all he
right
does
as the nominal defendant
own the membership interest in the member of the entity at issue. Got it.
Yeah, and so with regards to the transaction that's in dispute here, which is about who this 19.35% ownership interest transfers to, that pretty much makes my client the only person in this lawsuit who has the ability under New York's dead man statute to offer documentary evidence, which he did in the form of the operating agreement he proffered in this case, which contained the decedent's signature and clarified who the 19.35% ownership interest went to. And, which is precisely what he did here. And, everybody else in this lawsuit stands to directly gain or lose something by testifying about the transaction at issue here. But my client.
Can I just ask you one question? Because you're right. Your guy's the only guy who was there. The LLC agreement was never changed to sort of mesh with the testamentary gift, was it?
No, that's not our position.
Right. So
yeah.
So there's no doubt that as far as TJ Montana is concerned, that the testamentary gift was not acquiesced to or agreed to or anything like that. Okay.
Right. Yes, and and that is essentially, I think, plaintiff's counsel was mentioning a case called Hillowitz, and we would agree with the sentiment that plaintiff had put forth for that as well. But ultimately, again, our main position is that of all the parties in this lawsuit, the only party who can produce documentary evidence that isn't barred under the dead man statute, right, which clarifies the major issue before the court, is my client, Andrew Lichtenstein. Okay. And
yeah, we understand, and you're over time. So
okay, thank you.
Okay, so let's hear from Ms. Tamara Harris. Go ahead.
Thank you, Judge. I just want to address the last point that was raised regarding the dead man statute, because it's the most recent point. Actually, under the case of Acevedo versus Audubon, my adversary is incorrect in his statement of the law. Andrew Lichtenstein is an interested witness. There's actually a counterclaim against him and a related action against him for stealing our 19.35% in violation of court order that it be escrowed. Aside from being an interested witness, under the dead man statute, to introduce documentary evidence, you have to have an independent source that is not interested, which means that Andrew Lichtenstein by himself, contrary to what his counsel just said, can actually not authenticate this document. And it's quite clear that this case lives and dies based on the authentication of an operating agreement that's been produced in 4 different forms. Some of these forms have my half-sister, Allison's, initials on them when everybody agrees she wasn't a party. One of the main original forms, at least they allege is an original, from Andrew's lockbox is completely faded. The first 3 pages are completely faded. If you match that to the digitally enhanced copies that they gave Judge Bannon, where you have the first 3 pages with typewritten and handwritten interlineations all over the place, they're clearly not a match. So aside from having an inability to authenticate, even if Lichtenstein's affidavit was accepted, the agreement he attaches that he tries to authenticate doesn't even match the original lockbox version that he produced to Harvey Korn, and Harvey Korn signed an affidavit. On top of that, it's their burden of proof in a summary judgment motion, not only to prove they have an authentic agreement, an agreement that's clear and unambiguous, which I think we can all agree this one is cluttered with handwritten interlineations and cross-outs and illegible handwriting, but they also—
Let me ask you a question, Ms. Harris, on the provisions that appear to be really in dispute, though, are on, I understand, pages 4 through 6. Are those pages disputed?
That's an excellent point, because I just want to clarify, it's actually page 3 that has material terms. Page 3 actually indicates free assignability among members of family, and it also relates to one of the arguments that they make in their brief, which is an unpreserved argument by Mr. Lichtenstein about the right of first refusal. So there are material terms missing from the original, but yes, page 12 is critical. And I would like to address the issue of family. Unlike the Bleekman case, which is a Florida case cited by the appellants, where the term family was defined to include only children and to exclude the spouse and the girlfriend, this operating agreement has no definition for family. Family Court Act is—
Ms. Harris, let me stop you there. Did you raise this issue with respect to Betsy?
Yes, I did. And I'm glad you raised that. That was actually in Ethan Cobray's memorandum of law, which they did not include in the record on appeal, that Betsy would be considered family. So that was raised in the lower court, and that there's no definition of family here. Even under the New York Family Court Act, family would include two people with an intimate relationship with a child in common. That would be Section 812 of the Family Court Act. So for them to say that my mother is not his family after having 4 decades of a relationship and a child with a very devoted relationship, to me is ridiculous. But even if we were to assume that she wasn't family, all she had was a life estate. The fact that my interest would be contingent doesn't mean it didn't vest. Under the existing law, I have a present interest in the future enjoyment of that property, and I am his blood, and I am his family. That complies with page 12 and page 3 of the agreement regarding free assignability among members of family. I would also note their argument is completely unpreserved. On their motion for summary judgment, they didn't even submit an affidavit from Allison or Bernice, and Lichtenstein's affidavit did not even attack the integrity of the assignment. The first time they ever raised this argument about contingencies and remainder men is in the reply brief on this appeal. And notably, if you actually, I'm sure Your Honor has read the cases they cite, they all deal with trusts that were judicially declared to be void. And because they were declared void, the contingent interest was voided. Very much unlike this case. This is not a trust. This is an assignment which is valid, has never been declared void, has never even been attacked. They failed to meet their burden.
But Ms. Harris, if Betsy is not family, then is the assignment proper?
If Betsy is not family, the assignment is still proper. It is a life estate.
How's that?
Sorry? How so? Because even if there's no prohibition on there being a contingent interest. The cases they cite, like I said, there was a judicial decree that those trusts were invalid, which then invalidated the contingent interest. I can have a vested contingent interest right now. I have an interest right now in the future enjoyment of that property, and I am family. Her interest is temporary. It's the extent of her life. And
yeah, but your contingency is that you survive her, right?
Yes, and if I don't,
so let me finish asking, so we can go down this road, because this is along the lines of what I was asking the Harris attorney to begin with. So you could not take, your interest actually would not vest until, in fact, your mother passed away, right?
I agree with that. I believe if you look up the law, which I've done only upon reading a reply, this is the first time they ever raised the argument in a reply, so it's unpreserved. But in reading the law, you have a vested contingent interest, even if it's going to be in the future.
But it's contingent. It may not. Contingent means it may or may not happen.
But that's not barred based on the cases that they cite. Those
well, it may not defease, but the question is really is you can't give it to you now. So what would happen to it? Honestly, you'd have this interest kind of floating around in space. Nobody would own it. The LLC would be minus a 19.35% owner for the life of your mother. She couldn't do anything. You couldn't do anything. Nobody could do anything with respect to that.
Well,
is that how you understand it?
I respectfully disagree with that, Your Honor. That's not how I understand it. Because if God forbid, I should predecease my mother, it goes to my daughter, who is my father's bloodline. That is his granddaughter. If, God forbid, my daughter should predecease, it goes to Allison, the appellant, who I'm sure would not.
But ultimately, the contingency is that everybody's got, is that it waits until your mother's life is over.
You're correct, but because I'm living right now, as opposed to being deceased, I still have a vested, as opposed to a merely contingent.
But you couldn't take it now.
No, I couldn't take it now.
So what would happen to that 1935% in terms of the governance of this company, of TJ? Who would control that 1935% while your mother was alive?
My mother would be able to enjoy the proceeds.
Well, how could she if the life estate fails? Let's just assume she can't be a family member. Just assume. I'm not deciding.
The thing about it is,
happens to that interest?
Can I say one thing? I'm sorry, Judge. How could it fail if in their motion for summary judgment, they failed to introduce any admissible evidence attacking the validity of it when it's their burden of proof? That's not before this court at this juncture. If that's
all you're going to rely on, that's fine. but I think that we may have to reach the question that I'm raising, and we'll look into it.
May I say one thing that's important?
Before you say anything, let me ask you a question. With respect to this 19-point interest, Judge Gish was getting to the issues of governance. But what is the 19-point and change interest? What does that entitle? What would that entitle Betsy to? To money?
To money. So basically,
okay, and can the money be escrowed? Would that be a basis? Could that be escrowed at this point? Would that be a basis to save it?
Could it be escrowed? It could be escrowed. There's a court order existing right now that it be escrowed from Judge Bannon in a related case. So there is an order that it be escrowed pending.
And what about with respect to the governance? How is that 19-point that interest exercise governing the company?
Well, she would benefit from the proceeds of the rental income.
I understand that, but I'm talking about the governance of the company. She wouldn't be entitled to govern the company, correct?
I believe there's a provision in the operating agreement that discusses that, and it might limit the governance in terms of that with assignments. I'd have to review that particular.
So really, the issue is proceeds, the profits.
Yes, that's correct. But I think an extremely important point is even if we assume that the assignment fails, it doesn't matter. Because aside from failing to authenticate one true agreement versus the 4 versions, there's still a will, and that's pending. It's not ripe for appeal. It's pending in the probate court. So in the event that the assignment fails and they can't produce the one true version, we're left with a situation where this is going to pass through the estate anyway. The subsequent will trump this operating agreement. This operating agreement does not speak of restrictions. I hear that word from my adversary all the time. It speaks of the word freedom, free assignability.
Counsel, I don't understand. This is Judge Scarpula. How could it possibly trump the operating agreement? You can't amend the operating agreement unless there's an agreement among the parties. And that's the first question I asked. Was there agreement of the parties? And the answer was no. So there's no trumping the operating agreement.
Well, I would respectfully disagree with you. On page 12, it says that there's free assignability among members of family and it doesn't require consent. That's the first issue. The second thing is based on New York law. In order for an operating agreement to prevent a decedent from executing a subsequent will, there has to be a provision that
Counsel, let me interrupt you a
No,
second.
that is an opposite. That I want to just straighten that out. That's an opposite. That deals with where a person who makes a will or a grantor and a beneficiary make a contract for a provision to be included in a will. There are certain requirements. There is nothing, there is absolutely nothing, and it's totally commonplace in business agreements, particularly small businesses, where the partners decide upon the death of one or the other who can get that property, and it absolutely is enforceable over a will. Absolutely, the will cannot change that agreement.
Okay, I would respectfully
cannot.
I would respectfully disagree with you, and I would cite the case.
You can disagree with me, but it's black letter law. It's all right.
If I may,
I feel respected, so that's okay.
If I may, it's not. I think you're mistaken because there's ample law cited in this brief.
I know, and it's the law that I told you about, which is when it's a grantor and a beneficiary who can they can actually make an enforceable contract, but in the absence of an enforceable contract, the grantor can change their will at any time during their life. That is the black letter law. But as in a business agreement between partners, if they decide how that partnership should be distributed upon the death of one of them, that is binding. That is absolutely binding. A will cannot change that.
But it wasn't set in stone, Your Honor. Actually, on page 12, it said that he maintained the freedom to assign it to his.
But the assignment is restricted. It's a restricted assignment, but it's okay. I think we understand the different issues that are arising in this, and I think they're complicated. I'll give you that. Okay, thank you all.
Thank you.
All right.
Do I have a one for?
No, you have no rebuttal, sir. You didn't ask for it, and you don't get it. Okay. No.
That's
no.
fine.
You know what no means?
That's fine. Thank you very much, Your Honor.
Okay, Gore, Silpe versus Gorman.
May it please the court, and welcome to my attic. I'm Rich Schoenstein for the appellant. So the two orders that are on appeal today are both based on a faulty predicate. That's my fire alarm. Excuse me 1 second.
There's nothing else that could possibly happen today.
I don't know. I'm going to be happy when we go back to in-person.
Oh, I'm going to assume someone's cooking a salmon downstairs and it's not going well. And I'm going to hope I can get through this.
Well, it just shows you how late we've gone. If you're cooking dinner,
I know. I don't think there's a serious problem. Otherwise, I would run out of the door and beg the court's indulgence. Look, the two orders that are on appeal today were based on the view of the court below that the issues of malpractice had been determined in the matrimonial action, and that's just not so. In the matrimonial action, the only thing Justice Drager addressed is whether counsel's motion to relieve unfairly prejudiced the special referee.
Counselor, this is Judge Singh, and the issue I'm interested in, at least speaking for myself, is the issue of but-for causation. How have you alleged that here? Also, in light of our decision back in October, essentially affirming what the trial court did.
Well, your decision back in October.
On the appeal and the matrimonial.
Oh, sure. I gotcha. So,
how would you get a different result?
Because
where's the different outcome? They came in the middle of trial. Where's the different outcome?
Well, first of all, counsel would have been prepared. Different evidence would have been presented. He had opportunities to subpoena additional evidence and present additional evidence.
But that sounds like trial strategy. That just sounds like basic things that some lawyers will emphasize certain things and others will take a different tact.
Your Honor, I understand the trial strategy argument, but this counterclaim alleges a fundamental failure on the part of trial counsel to review the 13 trial binders that were prepared and ready for him, to submit evidence that he stormed out of settlement meetings and caused and obstructed the settlement.
So let's assume, okay, you're right about that, but how is that but-for causation? How did that affect, for example, equitable distribution?
Well, we spell that out in the third amended answer. And by the way, the first two versions of the answer were submitted before the matrimonial action had concluded and couldn't really address this. So it's only the second and third amendments, unfortunately, that address this issue. But we spell out
the referee's report. I mean, you still have to address but-for causation.
Well, we do.
What would have been different?
Your Honor,
what result would she have obtained?
For example, the court would have understood that her income was lower than what was represented to her by her counsel, and she would have received a greater award, a greater distribution at the time. The court would have understood that certain limited partnerships.
A distribution of what?
I'm sorry, that she would have received. That she would have received greater maintenance during the course of the proceeding, because the court would have understood she had less income.
During the course of the proceeding, what she got is the temporary maintenance according to the formula. The court didn't even look at the fact that they hadn't lived together for a long period of time. So I don't know that she would have gotten anything different. And by the by, this counsel didn't step in until that had already been determined, the temporary maintenance, and that was pursuant to a formula.
Well, he had an opportunity to address it, and he misinformed the court about the extent of her income. He misinformed the court about the ownership of the limited partnerships. He didn't inform the court that there was evidence to value the limited partnerships so that they could be part of the distribution.
I don't understand that. Again, what the valuation would have taken place before the trial. He came in the middle of trial. Whatever valuations occurred. And if it was right or wrong to get valuations, had nothing to do with this attorney, right?
Oh, he absolutely had the opportunity to seek and present valuation evidence.
When certainly discovery was over, right? Couldn't get valuations, couldn't exchange valuations, it was already done. That part of the cake was already baked. Right.
May I say, Your Honor, that respectfully, from my point of view, those are factual conclusions that you're reaching. This is a motion to dismiss on the pleadings. set
I'm
forth.
respected, but I disagree with that. I just,
Okay.
I just don't, I don't know how you do that. Came in at a certain point, if you're going to tell me that things were done from that point on that would have changed the result, then you might have a claim here. But you can't tell me about things that should have been done before they came.
No, but that
just can't be.
But that is what we say. We say he came in, he charged $400,000, and he couldn't even be bothered to read and study the trial binders that were prepared for him.
Well,
and he wasn't ready to litigate the case.
And okay. All right, let's hear from your adversary.
Good afternoon, Your Honors. May it please the court. This is Catherine Ryan with the law firm of Lewis Brisbois, counsel for respondent Gar Silpe. I'll keep it brief. Your Honors touched on it. The majority of these counterclaims concern strategic decisions and litigation tactics used by my client. They came in mid-trial. They were one of 8 sets of attorneys retained by Ms. Corman in the
Right, I understand, but that doesn't mean that they didn't commit malpractice, right? They didn't commit the malpractice that was attributable to the services of the prior attorneys that they can't be held responsible for. And that's what I was trying to bring up from Mr. Schoenstein. So the question really is they come in, a lot of days of trial have gone by. And in fact, even the plaintiff's been pro se for a couple of days. I think she may have even testified by then, So they get in and they have to complete the trial. There's still a lot left. Is there nothing in the pleadings about what they did that would have, that may lead to a but-for causation, an allegation of but-for causation?
Well, one of the comments that my adversary opened with was that the dismissal, so to speak, of Ms. Corman's counterclaims, her legal malpractice counterclaims, was on a faulty predicate, that the special referee and then the confirmation of that report by Justice Drager is what led to this dismissal of the counterclaims. And that's just not accurate. The decision from Justice Freed, the July 2019, on motion sequence 3, which is a motion to dismiss filed by Gar Silpe, filed by my office, to dismiss her initial set of amended counterclaims. This is a second set of counterclaims that she interposed. We actually stipulated to permit her to do so. We moved to dismiss those, and without any reference to any finding of the special referee or any decision of Justice Drager, Justice Freed found that those counterclaims failed to plead proximate cause and actual and ascertainable damages. So irrespective of the findings of Justice Drager in confirming everything found by the special referee, keep in mind these findings are allegedly the basis of the legal malpractice action, in the sense that, but for the alleged negligence of my client, these findings would not have been made. All of these findings were confirmed or slightly modified by Justice Drager.
Well, isn't it? I mean, part of their claim is that if your client had made a different record, that result would not have been reached.
Yes, and that is why the burden is on defendant Gorman to show proximate cause, to actually put forth facts showing that had different evidence been presented, different findings would have been made. Here,
so it's not enough to say that with 13 binders, they have to show what wasn't offered in evidence that somehow would have turned the case and was I guess a deviation. Every attorney would have put it in.
Of course, and just as a matter of policy, the reason this standard for legal malpractice is so high is to prevent the type of autopsy that's going on here, in terms of looking back on potentially 8 years of litigation, what was presented, what was ignored, what was said. And here, especially as opposed to perhaps another type of legal malpractice action, we're benefited by the fact that not only do we have the findings of the special referee, but we have a detailed 30-page report issued by Justice Drager, finding that all of those findings made by the special referee were based in evidence and
based on the record that was developed. Was this case at all influenced by the fact that at some point during the trial, these parties had a difficult relationship? Let me just put it that way.
Yes, I think, Your Honor, I think that is a theme for a lot of these matrimonial actions, in the sense that the issues are obviously very emotional. And I would make one point that the findings of Justice Drager, that decision came on a motion filed by Gorman herself to overturn the findings by the special referee. So in the sense that she was arguing that those findings were not supported by the evidence, or should have been supplemented by evidence that was not submitted by my client. Justice Drager considered that an issue.
No, she couldn't submit supplemental evidence. It had been tried. She could say that the referee made wrong findings, but the record was what it was.
Well, for example, there was an allegation that my client failed to present certain evidence concerning the distribution of a trust. And there's a portion of Justice Drager's decision where she notes that the special referee made her finding based on the consideration of the trust instrument and testimony of the experts. Under these circumstances, there's no basis to find that the referee was improperly influenced by wife's trial counsel. So it was taken into account whether the actions of my client put defendant at a disadvantage as to any of these individual issues.
Okay. All right. Any further questions, colleagues? Okay. All right. Well, thank you all very much. It's been a long day. This session of the Appellate Division is now concluded. Have a good evening.
Thank you, Your Honor.
Enjoy your dinner, Mr. Shorenstein.